Scott is first, my understanding. Didi.
Yes, Scott was here first.
Judge, is there anyone in your waiting room? The complaining witness was going to zoom in on Scott. Her name is Denise Williams.
Justin, maybe? Oh, no. I just- Okay, praise on Scott.
Hello.
Have you just stay muted? Thank you. All right,
Ready?
I'm ready.
Calling case 24002737-01-FH. People of the state of Michigan versus Nashonda Scott. This case before the court today for sentencing. Appearances for the record, please.
Good morning, Elizabeth Kellogg on behalf of the people, P84687.
Good morning, Your Honor, and good morning to your staff. Alana Altler, P number 87128, on behalf of Ms. Nishonda Scott, who stands to my left. Ms. Scott, could you please state your first and last name?
Nishonda Scott. Okay, all right. Madam Prosecutor, today is the date and time set for sentencing. Have you reviewed this pre-sentence investigation report?
I have, Your Honor, I have no additions, deletions, or corrections, and I believe the guidelines are scored correctly 0 to 9.
Okay, all right. Madam Defense, have you gone over this report with your client?
I have, Your Honor, and we do have several corrections to the report.
I'm listening.
I'd like to direct the court's attention to page 1 of the basic information report. Her last known address should be updated as that reflects the address of the complaining witness. So Ms. Scott's new address is 204.
Wait, I'm sorry. Because there are multiple page one?
Mhm. The top cover page.
Top. Okay, go ahead.
Yes, it's 20490 Greenfield Road, number 7. Detroit, Michigan.
Okay.
Okay. Her occupation on that same page should be changed to crew member.
Okay.
And then those same changes we are requesting to be corrected throughout the PSIR. The next page where that would be appropriate would be the first page of the pre-sentence investigation, which is, I believe, the 5th page of the PDF of the document. So it's the first paragraph under evaluation and plans.
I see.
Yep,
Okay.
the address should be changed, and then in the 3rd paragraph, the occupation should be changed as well because she's not a cook. She's a crew member. And then finally, Your Honor, that those same changes should be made in the education and employment section of the pre-sentence investigation report. It says page 7.
Okay.
And those are all the corrections we have, Judge.
Guidelines are scored at 0 to 9 for the record. In agreement?
In agreement, Your Honor.
Okay. Ma'am, I need to hear from you directly. Did you go over this report with your attorney? Unfold your arm. Did you go over this report with your attorney?
Yes.
Any changes, deletions, corrections to this report?
No.
Okay. Anything from the people before sentencing?
Yes, Your Honor. Here on Zoom, we have Miss Denise Williams. She is one of the complaining witnesses on this case. I'm not sure if she would like to address the court or not, or if she just wanted to be here today. Ms. Williams, if you do, can you hear us? If you can, please unmute.
Yes, I can hear
Thank-
you.
Okay, Ms. Williams, Judge, if I may.
Yeah, go ahead.
Thank you. Ms. Williams, would you like to say anything to the judge about this case?
Well, I just want to say, I just appreciate whatever's going on, that my daughter can get the help that she need. I really appreciate that, and I just hope that later on down the line we can come together, maybe get some counseling after all this is over. Not now, but when the process to start for her to get the go through the challenge that she have to go through. My understanding that she's going to be evaluated, or the case, I believe. So I'm not for sure if that's the case, but maybe we can both get counseling later on after all this is over, for her to get um, you know, herself together, and maybe later on we can go some counseling.
Thank you, Ms. Williams. You can remute yourself.
Thank you. Anything from defense before sentence is imposed?
Yes, Judge, there are a few things I'd like to say on Ms. Scott's behalf. When Ms. Scott was in jail for this offense, she looked at me across the table and she looked me in the eye and she said, "I am going to turn my life around as soon as I get out of here." She made that promise to me, Judge, and she made good on that promise almost immediately. As soon as she was released, she found a job and she started working as a crew member at McDonald's, and she took any shift that they would offer her. Within a month, she was earning enough money that she could find her own place to live. She found her own transportation to work every single day, despite not having a car. She has also engaged in a considerable amount of personal reflection, realizing that this is an inflection point in her life, and she doesn't view this agreement or deal as an impediment or burden to her. She views it as an opportunity to better herself. As for her future, she plans to return to the Dorsey School of Business so she can obtain her license in cosmetology. And during the course of this case, I would just like to add, she has not violated the terms of her bond, not once. She has complied to the letter of the law, and she has shown up to every court hearing early, impeccably, and ready to learn what's next for herself. Simply put, Your Honor, it is an honor to represent her. Finally, because she is working, but only because she is earning $13 an hour, I would ask that this court waive any discretionary fees, as Ms. Scott is indigent still at this time. And because GPS monitoring is not part of the sentence agreement here, I would just ask for this court to enter an order today for removal of that GPS tether. Thank you very much.
Madam Prosecutor, is there any objection?
To removal of the tether, Your Honor?
Correct.
No, no objection.
And I do agree, it's not a part of the agreement. I haven't heard of any violations, so, okay. Ma'am, is there anything you would like to say before sentence is imposed?
No. I'm just thankful and grateful that God gave me another second chance to turn my life around, and hopefully when all of this is over, like my mom said, we can go to counseling and we can go on about our lives in a positive state, not so much of negative, and things will be better because I am working and I will have my own place of residence, and we can just continue to move forward.
Okay, so there, and I'll talk more about that momentarily. There was a sentence agreement in this case, and it is the court's intention to honor that agreement for the charge of assault with a dangerous weapon, felonious assault. You are sentenced to probation for a period of 2 years. Rehabilitation goals are to remain crime-free. The following conditions apply. You must take medication as prescribed by a licensed physician. You must complete a psychological evaluation when referred. I am adding, you must complete a substance abuse assessment. That's not a recommendation based upon what I read. I am adding that. You must complete a substance abuse assessment and complete any recommended treatment. You must complete mental health, domestic violence, or other recommended treatment following assessment by a qualified community-based service provider. No contact, no verbal, written, electronic, or physical contact with Denise Williams or Gerald Williams, either directly or through another person. You must not be within 500 feet of their residence, school, or place of employment. The following fees are assessed: crime victims assessment $130. Supervision fee is $30 per month. Court costs I'm not going to waive. And this is very serious business here, and I'm going to speak a little bit more about that. She doesn't have to pay it right now. She won't get violated over it. There is a lot that goes along with, this process. So, but I do believe that she's trying as well. So I'm going to cut them in half, $650. Attorney fees, $400. State cost $68. Crime victims, that's it, yep, crime victims, $130. Your appellate rights, it is my duty to advise you that you have the right to request leave to appeal from the Court of Appeals. If you are unable to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare post-conviction motions or perfect an appeal. You are further advised that if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. You have just received a form advising you of these rights, and I request that you sign receipt of that form with the clerk within 42 days of today's date. If you intend to appeal and need to have counsel appointed for you, and again, she has it now in front of her, is that right? Okay, all right, and then Corporal Beatty's just about to hand you a map to the probation department. You'll go over there and you'll one block over and they'll get you started on your probation. A couple of things I'll say in closing. I am hopeful that you'll do well on this probation to this court, but I do want to note a couple of things. I think you get it, but I want you to hear it from the court directly. You don't have any prior record, you were cooperative. I know that there are some mental health concerns, but this is, very serious business. You could have been facing a very different charge here today. There was a stabbing over like little to nothing over getting a job. I mean, based upon what I read, and you ended, no, I don't want you to say anything. It's not a discussion. I just want you to listen to what I'm saying. And you indicated, and I think you get it again, that you paid your debt to society. Not yet. You have to successfully complete this probation. That's all I'm saying to you. And so until there's further order of the court, there is no contact. We're not at that point. If something changes down the road and the request is made of the court, that's different. But I just want to make that clear as well. Good luck to you again. I am hopeful that you will do well. Thank you. Off the record on Scott.
Mr. O's right, he said it's quick.
Okay.
Thank you, Your Honor.
Thank you. Take care.
Your email. Julia, you write it down.
Okay, so it's Salmons and then who? I know Ms. Hadar is here. Is Mr. Gozy here?
He was.
He was.
Okay.
I think he's in the back.
Okay, he has several on the docket today. Okay. So I know I have a couple of max set of him, so. Okay, parties on Salmons. Okay.
Calling case 24000429-01-FH. People of the state of Michigan versus Anthony Salmons. This case before the court today for a final conference. appears for the record, please.
Good morning, Your Honor. Bryn Kurt on behalf of the people, P 84009.
Morning, Judge. Neighborhood Defender Service of Detroit by Glen Oak, PA 3424, appearing on behalf of Mr. Sammons, who's present in the courtroom. Mr. Sammons, please state your name.
Anthony Simmons.
All right. Where are we?
The judge. Go
So,
ahead.
Your Honor, I do know that we were here twice earlier this month, I believe. My supervisor did stand in for me. I did receive emails. I did make a call to the complaining witness this morning, which today's my first day back in the office. I left a voicemail. I have not heard back from her, Your Honor. I'm just simply asking for a little bit more time to be able to get a hold of her.
Okay, well, we have a trial date for August 16th,
Yes, Your Honor.
so
Judge, any day the week of July 29th work for the bench for an adjournment.
next week you're out.
I am, Judge. Although I'm in this courtroom on July 26th, so
Yeah, I was gonna say July 26th.
I can do that, Your Honor.
Yeah, that's 1 week. Okay, so I'll put it over to July 26th.
Thank you, Your Honor. I appreciate it.
Okay, off the record on cameras. Of course.
Okay.
Where I have match sets.
Mr. Glenn is ready and Roger. You
Um,
ready and Roger?
no, I want to speak to you.
Okay.
Okay,
Well,
I just
then,
haven't had a chance.
John Moore is ready. They were next.
Okay.
okay.
I just need to ask.
Ready?
Good, thank you.
Okay, so parties on more. No. Yeah, I saw it.
He wants to go, Judge.
Parties on, yeah, that's fine. I'm not,
I can waive his appearance.
yeah, absolutely. And then we'll come to the Dozy cases.
Okay.
Yeah, it's like, I think 3 here. All right, parties on more. Corey, are you ready?
Yes, Judge.
Okay.
Okay. Calling case 24002503-01-FC. People of the state of Michigan versus John Moore. This case before the court today for a final conference. Appearances for the record, please.
Good morning, Your Honor. Brendan Sawyer for the people, P 83033.
Good morning, Your Honor. Jonathan Simon, P 35596 on behalf of Mr. Moore.
Okay, so it's my understanding he's refusing to come out of his cell. I'm not going to have any deputies force them out or anything. So we're just gonna waive this hearing.
Yes, Your Honor, no objection.
Okay, all right. So we are here today. We have a trial date on August 19th, but first we have a defense's motion to quash. I've read it.
Judge, I'm sorry to interrupt, but just this week, apparently, Mr. Moore had also filed a number of, I guess, motions, which I just became aware of when they were emailed to me by the court a few days ago. There are a number of issues here that I got 10 pages single space, which I would like to review and which I would like to go over with Mr. Moore. And perhaps there may be additional motions which I may need to file.
Absent some extraordinary set of circumstances, that's not how this works. Motions were due on the 4th and you filed accordingly. I think you actually filed even earlier than that. And so absent something that was not known, he's not a lawyer, you're his lawyer, you filed a motion to quash that the court's going to rule on. It's unlikely that I'm going to consider any further motions with the trial date looming. Again, that's not my absolute final answer because it just ultimately depends, but it's unlikely.
Well, I would say this too, Your Honor. One of them is dated May 2nd, one of them is dated May 30th. I don't know when they were filed. I don't know how they were filed. I just know that I just received them this week.
I understand, and I'm just telling you that Mr. Moore is not going to dictate the processes of the court. Like the not coming out today, the filing, no. Absent some extraordinary set of circumstances, it's unlikely. The court puts a lot of work into ruling on motions. We have a trial date looming. Now again, hold on one second. So they weren't filed, it's my understanding, at all. And it said something about 36 district court. So we just received them when you got them. So that's all I have to say about that right now.
Thank
No,
you.
we're done.
Well-
But on that point, we're done. And if you want to, once you take a look at it, and if you want to make a plea to the court, you haven't even looked at it. So there's no more to say. Take a look at it. And if you want to make a plea to come back before the court, then I'll consider it based upon what's even filed, but they aren't actually even filed. That's why I made quotes over here. There's nothing more to say until you look at it and see if you want to make another request before the court. As it pertains to your motion to quash, I have read the motion, I've read the response, and the transcript. And I don't mean to be short, but because I know you're trying to do your job, but nothing's going to change today based on you haven't even read it. So you can't make that plea to me. That's all. All right. So I've read everything. Is there anything you'd like to say for the record?
No, Your Honor, I would rely on my brief.
Okay. Anything from you, Mr. Sawyer?
No, Your Honor, I rely on my written submission.
Okay. So I have a question for you. Mr. Simon, where does it say for assault with intent to murder that he has to have actually been injured? Because you make a lot of the fact that it was only a raised wound. Where does it actually even say that he has to be injured at all?
No, there is no requirement. It's purely a matter of intent. I'm just suggesting that the facts indicate there was a different intent, if any.
So there are 4 shots fired in close range. And again, according to the transcript, the defendant said, "I'm going to gun you down." A handgun is used. I mean, these are all the things that the case law tells us to look at. You know, you don't have to have words there, but you know, first of all, the case law in this area starts off with, I think it's people deceiving. It's impossible to really get inside the mind of another person. And so you start to, so you really only need minimal circumstantial evidence because again, you can't exactly get inside the mind. So you have 4 shots fired, close range. I'm going to get you. The fact that he was not the best shot or complaining witness was lucky does not, and we're at a probable cause standard here to bind over. And then we're at an abuse of discretion standard once again to me. So I just say all these things for the record. Low to bind over, very high burden to overturn it, to find an abuse. So again, deadly weapon, close shot, 4 shots, close range. I don't think there's much more to say. I cannot find for the reasons stated that there was abuse. Now, who knows what a jury may agree with you that this is not A1, this is something else, or this is nothing for whatever reason. But again, for a bind over, I do not find that there's an abuse of discretion for the reasons stated on the record. Did you ask for a DSU report?
I think we already had a bond hearing the last
Okay.
time.
It is, because it's dated, and I would have, okay.
I believe that reduction was denied, consistent with the recommendation. Your Honor, given that Mr. Moore is not present in the court this morning, I would ask if the court could set a final pretrial conference. I don't want to be an issue that he was unaware of the offer. Even though I did tell him this morning, I think it should be in open court.
Say it again.
There's a case of Lafler versus Cooper. I believe that he's entitled to know what that offer is.
Oh, I know that case inside and out. I was just trying, I didn't hear what you said. Trust me. He's entitled to hear it, but he can't stop himself from hearing it. So for the purpose of the court, Mr. Sawyer, for the purpose of the record, please tell me what the offer is.
Yes, and I've conveyed this to Mr. Simon prior to today's court date. The offer is that Mr. Moore would plead guilty to count 1, assault with intent to murder, punishable by a statutory maximum of life, and the associated weapons felony firearm, which is count 5, punishable by a mandatory 2 years in the Michigan Department of Corrections. As part of a plea to counts 1 and 5, the people would dismiss counts 2 through 4 and 6 through 8, and would withdraw the habitual offender. I believe it's a 4th offense notice. Yes, we would withdraw the habitual 4th offense notice. A sentence agreement of 5 years to 15 years on count 1, which would be served consecutive to the mandatory 2 years in the Michigan Department of Corrections on count 5, and any standard conditions that the court may impose at sentencing.
Okay, 5 to 15 plus 2. I understand for the purposes of the record. And yes, Mr. Simon, I will give you a final conference, if you will. Let's see. Next Friday, the 26th.
Works for the people.
26. Yes, that's fine. Thank you, Judge.
I'll see you next week.
Thank you, Your Honor.
Thank you. Hardwick?
Mr. Gozzi's not here.
Oh, okay, never mind. Okay, who else is here then?
Mr.
Oh, Health.
Health and Clean Health.
Ready on Your Honor.
Well, in terms of order, yeah.
Oh, sorry.
Yeah, she
Are
was
they
here.
ready?
I think
Okay,
I was-
come on.
Did you, was this my copy or that's your copy? Okay, so the judge has a copy, you have a copy? Perfect. Yeah.
He's right here. This is a. Mr. Gozzi's back.
Okay, well, Mr. Gozzi. I gotta do health and so Mr. Gozzi takes around a couple minutes, but I know what it's like on a Friday, so.
If you want to pass on our matter, we'll wait.
Okay. Hardwick.
Because he was here before us.
Actually,
Did
four
he go?
matters.
She has 4, he has.
Oh.
So she said, never mind. All right. All right. Says there is a limit to her kindness. All right. I'm ready.
Calling case 24003364, 1-FH. People of the State of Michigan versus Kevin Helton. This case before the court today for a pretrial. Appearances for the record, please.
Elizabeth Kellogg on behalf of the people, P 84687.
And good morning, Your Honor. May I please this honorable court, Rita Young, P 44626, appearing on behalf of Mr. Kevin J. Hilton, who is also present, standing to my left. Sir, would you state your full name for the judge, please?
Yes, my name is Kevin J. Helton.
Okay, so again, we're here today for a pretrial. I do know for the record, because I did check, Mr. Hilton did get the ram tether as ordered after
Yes.
our last hearing.
And I paid for it.
I didn't hear you.
And I paid the charge that was for that.
Okay, all right, so here's the parties have reached resolution in this matter. Ms. Kellogg, if you will place the terms of the plea and sentence agreement on the record.
Absolutely. It's going to be a plea to count 1, third offense, operating while intoxicated, and the habitual offender, 4th offense notice. The people will dismiss count 2, possession of controlled substance. There is a sentence agreement of 2 to 5 years MDOC, or excuse me, that should be. Your Honor, there was a typo in that. Quite a serious typo.
With the habitual 4?
No, with regard to the sentence agreement, as discussed and agreed to by myself and defense counsel was 2 to 15 years. It looks like I missed the 1 on the 2 to 5.
Right, as it relates to the habitual.
Yes, because the tail would have to be 15.
So I have no
No.
objection, Your Honor, to adding.
No, hold on a second. For a 4th, the tail could be up to life. And so you're saying that it's going to be 15.
Yes, I apologize, Your
Okay.
Honor. Yes, correct.
Okay, I just want to make sure we're on the same page. Okay, Ms. Young, now what will you say?
I have no objection to the court modifying that 2 to 5 to 2 to 15.
Okay,
Thank you, Judge. My apologies.
no problem.
And this will be a no contest plea, Your Honor, based on lack of memory. As also noted on the settlement.
So long as it's and in these types of cases, I could believe it. If there's some indication that he really didn't know what was going on. Ms. Kellogg?
Yes, there is, Your Honor. There is indicate, yes.
Okay, okay, all right. Anything else?
No, Your Honor.
So this is the full and accurate understanding, 2 to 15 years in the Michigan Department of Corrections. I've changed it from 2 to 5, 2 to 15, and put my initials there for the record.
Yes, that is correct, Your Honor, and no additions or corrections.
Okay, all right. And sir, is this what you would like to do?
Yes, Your Honor.
Okay, state your name and spell it.
Kevin J. Helton. Kevin J. Helton. Spell it, Your Honor.
For the record, correct.
Kevin, middle name Jay, last name Helton.
Okay, raise your right hand. Do you swear or affirm the testimony you're going to give the court will be the truth?
Yes,
Okay, you can put your hand down. How old are you, sir?
54.
How
I
far have
mean,
you gone to
52,
school?
52, Your Honor. I'm 52.
Okay, how far have you gone to school?
Graduation
From?
from high school.
Okay, so you read, write, and understand the English language?
Yes,
Okay, I'm going to ask you a series of questions. If at some point you can't hear me, you don't understand, I want you to stop and interrupt me so that I can in fact repeat the question or explain, okay?
okay,
Having said that, if I ask you a question and you give me an answer, I'm going to assume that you understood the question and that the answer you gave is the answer that you intended to give. Do you understand?
yes,
Okay. For the charge of operating while intoxicated, third offense notice, how do you plead?
no contest.
Okay. And as a habitual offender, 4th offense notice, how do you plead?
No contest.
Your Honor, I would stipulate that it does have
Okay.
a minimum of 3 prior convictions. If you
Right.
need the dates, I can give them to you.
No, if there's a stipulation that this is his, based upon the stipulation, because I need it, yeah, that can't be no contest, that has to be.
It would
Yes.
be guilty.
Okay,
Yes, Your Honor. There will be a stipulation.
And move
Okay.
to strike what my client just said with respect to guilty as to the habitual 4th. Your Honor. And we stipulate that he does have 3 prior OWI convictions, right, counsel?
Yes.
okay, all right. Sir, I'm holding a form that sets forth the plea and sentence agreement in this matter. And have you seen this form before?
Yes,
Is this your signature on this form?
yes, it is.
Okay, and did you sign this form after you had an opportunity to review everything fully and completely with your attorney?
Yes,
Okay, Do you have any questions regarding the plea and sentence agreement?
No.
Do you understand that by pleading to count one, operating while intoxicated, third offense, and you're also pleading as a habitual offender, fourth offense notice? So operating while intoxicated, third offense, that's a statutory maximum of 5 years in prison. You understand that?
Yes.
Okay, and so I'm confused by this plea agreement, now that I'm looking at it closer again. Third offense, 1 to 5. Is that what you're conveying? Is that accurate?
Yes, Your Honor, the penalty is between 1 to 5 years. That was my reading of the statute.
Okay, I just want to make sure that that wasn't, okay, all right. So statutory maximum is up to 5 years. You understand that?
Yeah.
For that charge. And then you're pleading also as a habitual offender, fourth offense notice. Your lawyers already stipulated that the lawyers have already stipulated that you have 3 prior felonies. The statutory maximum could be up to life. However, pursuant to the terms of the plea and sentence agreement, the statutory maximum is 15 years. Do you understand that part of this?
Yes.
Okay, so in sum, for those 2 charges, count 1 and count 3, you are agreeing to serve a minimum of 2, maximum 15 years in the Michigan Department of Corrections. Do you understand that?
Yes.
Okay. Any questions at all about anything I just said?
No.
Okay, do you still wish to proceed?
Yes.
Okay, and also pursuant to the terms of the plea and sentence agreement, count 2 is dismissed. You understand that?
Yes.
Okay, all right, by electing to plead no contest today, you're waiving a number of important rights that you would have if you decided to go to trial. Those rights are listed on the form that you signed, but I still go over everything with you on the record to make sure that you understand. You understand that you have the right to be tried by jury,
Yes.
to be presumed innocent until proven guilty,
Yes.
to have the prosecutor prove you're guilty beyond a reasonable doubt.
Yes.
Do you understand that you have the right to have witnesses appear to testify against you?
Yes.
Understand that you have the right to question or cross-examine those witnesses through your attorney.
Yes.
Do you understand that you have the right to have the court order any witnesses you would have for the defense to appear at trial?
Yes.
Do you understand that you have the right to remain silent during trial?
Yes.
Do you understand that that right cannot be used against you? So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they cannot use their silence against you in reaching a verdict. Do you understand that?
Yes.
On the flip side, do you understand that you have the right to testify on your own behalf if you chose to do so, to tell your version of facts?
Yes.
Do you understand that by pleading no contest, you are giving up all the rights you just reviewed?
Yes.
Other than the plea and sentence agreement placed here on the record today in court, did anyone promise you anything else to get you to plead guilty?
No.
Anyone threaten you or any way force you to plead guilty today?
No.
Do you understand that if I accept your plea, you will be giving up any claim that your plea was a result of a threat or promise unless you tell me about it right now?
Yes.
Are you pleading no contest freely, voluntarily, of your own free will?
Yes.
Are you currently on probation or parole?
No.
Okay. Do you understand that by pleading no contest that you are giving up the right to appeal your plea as a right? And even though the Court of Appeals may grant you leave to appeal, it is not obligated to do so?
Yes.
Do you understand that if your plea is accepted, that you may be giving up the right to appeal issues that otherwise would be appealable to you if you were convicted at trial?
Yes.
Oh, that's a factual basis.
Your Honor, I will be reading from the investigator report, if that's okay with Ms. Young.
No objection.
Your Honor, on October 26, 2021, Lincoln Park police officers were dispatched to 3065 4th Street in Lincoln Park, which is in Wayne County, for a male passed out behind the wheel of a running vehicle in the street. Officers observed the male, who was later identified as Mr. Kevin Helton, sitting in the driver's seat unconscious but breathing. Officers administered Narcan to him. After that, he became conscious. During the investigation, a blood sample was taken from Mr. Helton that was later tested by Michigan State Police. His blood was tested and it contained 0.096 grams per 100 milliliters for alcohol. And I believe that satisfies the elements of count 1 operate. Oh, excuse me, defense, do you stipulate that Mr. Helton had at least 2 prior convictions for operating while intoxicated?
So stipulated.
Your Honor, I believe that satisfies count 1. And then defense, will you stipulate that Mr. Helton has previously been convicted of 3 or more felonies?
So stipulated, Your Honor.
Your Honor, the people are also satisfied with regard to the habitual offender 4th offense notice.
As it pertains to the no contest plea, is it that he was actually passed out? Like what part?
He has no memory of.
Okay. Okay. Are you satisfied?
Yes, Your Honor.
Satisfied?
And satisfied, Your Honor.
The court finds that the plea is understanding, voluntary, and accurate, and will accept a no contest plea. Mr. Helton will be referred to the probation department for a pre-sentence investigation report.
Judge, as to sentencing, he is single, 52. He is asking if the court would be so kind as to give him at least 3 weeks to get his affairs in order, get out of his lease, quit his job with the VA hospital. And,
Well, luckily for him, it takes 4 weeks to get this.
oh, cool.
Which puts us like right at our move. And so I'm gonna do this on August 22nd. It cuts probation 1 day short, but we'll have to figure out how to get this done. It'll be okay. So August 20, yes, August 22nd for sentencing.
Thank you very much, Your Honor.
Okay, and so you're gonna go to the probation department and corporate media, I know just gave you a map to schedule a pre-sentence investigation interview. And as part of that process, they will ask you questions, ask you for documents. You should be 100% cooperative because they will use that information to compile a report that I need for sentencing. And I don't think there'll be an issue, but if there is, because I've taken your plea in sentencing, I don't have to honor this. So just do everything you're supposed to do.
Yes.
I'll see you on the 22nd.
Thank you, Your Honor.
Off the record.
Thank you, Your Honor.
Hardwick.
Yeah.
After I handle these cases, then I'll come to felony non-support.
Yes, I am.
Hardwick. Is the prosecutor here for Hardwick?
Yeah.
Was.
Ms. Moore?
Hold on a second. Did I give you this file back?
Oh, yeah, no, absolutely.
I don't have it. Thank you. I'm ready.
Calling case 24001851-01-FC. People of the state of Michigan versus David Hardwick. This case before the court today for a final conference. Appearances for the record, please.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P 84724.
And good morning, Your Honor. May it please the Honorable Court, Eric Gozzi on behalf of Mr. David Hardwick. Mr. Hardwick, could you please state your name for the record?
Yes, David Hardwick.
Thank you.
Okay, so there's a lot more than a final conference going on, just for the record. The court received notification of an alleged tether violation on Monday after hours, alleging that Mr. Hardwick cut his tether and had absconded. And then as a result, the court called an emergency hearing on the following day, on the 16th, where bond was revoked and a bench warrant was issued. Mr. Hardwick is in custody. How is it that he ended up in custody?
Your Honor, my understanding is that after he absconded, he then went to the Redford area and essentially picked up another case. I have provided a copy of the information to defense counsel. I have a copy of the investigator's report of that second case. Yes, may I approach?
You have this, Mr. Goldie?
Yes, I do, Judge.
Okay, all right, let's talk about the issue of bond. We'll take the warrant out of the system because he is here, but let's just deal with that. Anything you'd like to say, Mr. Goldie?
Yes, Judge. Mr. Hardrick is before Your Honor with, not on his own accord, of course. And it is factually true that he does have a pending case. That case is scheduled for a probable cause conference on the 30th of this month in front of Judge Khalil of the,
Redford.
I was thinking the number, but the Redford
17.
17, thank you, District Court. An examination obviously will be scheduled thereafter. With respect to his current status, you had indicated that you remanded him. I would ask the court to consider a cash bond. And I'm also asking the court for a DSU report, just so that we can, see what their thoughts and opinions are. Would point out one thing though, if I don't want to get into too much detail here, but Mr. Hardrick is a survivor of a rather lethal disease. Ask that his file at least be marked medical. He will need continuing treatment while he's in the Wayne County Jail. Specifically, I think it is radiation and chemotherapy.
Okay. Go ahead.
Thank you, Your Honor. I would also ask that the defendant's file be marked medical because the people at this time are objecting to the defendant receiving any bond. As the court is now in possession of the investigator's report for this new case out of the 17th District Court, the defendant was then charged with 3 felonies. The first one being assault with intent to commit a felony, bond, absconding or forfeiting, police officer resisting and obstructing, and the misdemeanor aggravated assault. Given the defendant's actions in the past week of cutting off his tether, going to a different area, picking up new charges, and leading to the assault of yet another person, I think that the defendant is demonstrating a number of issues. Now, the 2 that specifically relate to bond in this case are safety to the public, or safety for the public, and flight risk. And the defendant has demonstrated in just the past week alone that he raises significant red flags for both of those. I would also like to note, and I did state this in the motion that I filed earlier this week to revoke his bonds, that when we were here on this current case back on June 14th, the court specifically inquired into the defendant's bond because the defendant was out on tether with, I believe, house arrest conditions. And the court asked me about his prior history. I indicated that he was a habitual 4th offender, and you specifically said, you looked at it and you said, so he's not a true 4th, meaning that he actually has more than 3 prior instances. And you warned the defendant that if there was absolutely any violation to his tether conditions or to his bond conditions, that he would be remanded to the Wayne County Jail. Here we are a month later. He has not only had a general violation for his bond and his tether, but he violated it in such a way that after cutting off his tether, he went on to get a hold of someone, keep them in an area leading to their assault, and then resisted officers when he was arrested. So I think that there is no reason that the defendant should be granted any bond under the circumstances.
I do agree. This is very, very concerning. I don't think there's much to talk about. He is awaiting bond on, I believe it's 2, he's out on bond awaiting trial on CSC 1.
Counts of CSC
2 counts of
first.
CSC 1, 1 count of CSC 2, a count of CSC 3. 1 is up to life, possibly. If he's a habitual offender 4, mandatory 25. And after all of that, because the court didn't set his bond, and he had been coming to court, the court voiced its concern he walked out of here multiple times, had come back, but the cutting of the tether alone is, for this court, sufficient of a remand. But cutting of the tether and picking up a new case, also assaultive in nature, He is remanded until further order of the court. Mr. Goldie, if you want a DSU report,
I would
you can,
like one.
of course, request one. It is unlikely, because I know this case better than pretrial services does, that I would sign any sort of order that releases him from custody prior to adjudication of.
Understand. We understand the position, Judge, but still, we think that a DSU report would be beneficial for all parties.
We'll request it.
Thank you, Your Honor.
Okay, we have a trial date.
Yes, we do, Judge, and there is an outstanding discovery issue. I did not formally submit an order. I've been speaking with Ms. Moore. She and I have a good relationship with respect to these types of issues. Specifically, I have paper discovery only on this case, and I understand that there might be some outstanding video, some statements, some body worn camera also. So I would just obviously expect that we will be getting that soon. If I don't hear back from the people, if they're having difficulty as well, I will formally submit an order or motion requesting the same so that we can make sure that we have everything that people and the police have in their possession.
Response, Judge. Defense counsel did submit a long list of discovery items. I am working on a few of those that we do not have. Defense indicating that he has no digital discovery or anything other than paper is news to me, so I will send him over. I wonder if part of the issue is that there was a previous defense attorney. He unexpectedly went on medical leave, and so Mr. Gozzi has graciously stepped in on this case. And so I will make sure that Mr. Gozzi himself has that, because there was also a phone dump that was sent or that was handed over. It was too large to send. It was handed over to prior counsel. So that may be part of the issue, but I am diligently working on that. There are a couple of medical records and lab records that are outstanding that I followed up with last week. They're still not available, but I should be getting them over to defense counsel shortly. Go ahead.
No, please.
I was just going to say that I would ask for another court date about a month out. I'm hoping to have all of that for defense, and that will still be 2 months before the trial date.
That sounds fair, Judge. And in all honesty, I have access to everything prior counsel, Mr. William Noakes, had, and nothing was placed on our server, which is where our discovery is traditionally held. So I haven't spoken specifically to Mr. Noakes regarding any cell phone dumps, nor have I received any of the same. I take Ms. Moore at her word. I have no reason to think that she's being misleading. So I will reach out to Mr. Noakes personally and find out if he does have that in his possession at this time, and I might alleviate a lot of these concerns.
Okay, so August 21st.
That's the judge.
Amen.
Thank you, Your Honor.
You're welcome.
And of course, this file is marked not applied for.
I'm actually going to
Thank
sign an order to say to make sure that he's evaluated and receives the treatment.
Appreciate that so much, Your Honor. Thank you.
Lawrence, you know you have to change the facts.
No. Especially not for just 12 days. I was only out Monday and Tuesday.
Yeah, could you step out in the hall?
Okay, it's almost harder so that game.
Oh, yeah.
Because people don't know, and it's like, we're not on hand, we're coming in, so and I'm hoping that people are just gonna cover it.
Right. Yeah, I asked her.
I'm trying to say.
Were they there for him?
Yeah.
Yeah, it was the demeanor, all while prosecution's talking. It was all of that. Why did she need to? Lawrence.
Child support. For the.
All right. Wait.
Calling case 24000493-01-FC. People of the state of Michigan versus Shantone Lawrence. This case before the court today for a pretrial. Appears for the record, please.
Good morning, Rhonda Hadar for the people, P 84161.
Good morning, Eric Gozi, on behalf of Mr. Shantuan Lawrence.
Okay, state your name.
Shantuan Lawrence.
Okay, so we had a trial date. We don't need to reinvent the wheel in the entire record, but it was initially scheduled for June 24th. It was adjourned to October 7th. Where are we in terms of, based on my recollection, the people were possibly consulting an expert?
The people have consulted an expert. That expert has begun working on a report to evaluate the competency to waive Miranda for Mr. Lawrence. As of July 5th, the expert contacted me and asked for help in securing Mr. Lawrence's school records from Detroit Public Schools. He then contacted me again later that day and indicated that he was able to secure the records on his own and that he would turn them into me to give to defense as soon as he got them. I haven't heard back since. I sent him an email yesterday and I asked for an update. He's usually pretty responsive, so I'm hoping he'll respond today, or I don't know if he's on a vacation or something, but I will contact defense and I can let the court know as well as soon as I have an update on the report. Otherwise, no other outstanding issues for the people.
I would suggest that we just schedule another pretrial just to see where we stand with this. If the people are planning on filing a motion in limine, et cetera, or if I am planning on filing a motion in limine as well.
Sorry, I did. There was a witness that the police were able to speak with last month in this case in June. I turned over that witness statement to defense counsel. In reviewing that witnesses, what I anticipate their testimony will be based on the statement. I believe that there is going to be like a small motion in limine relating to a potential hearsay issue that they might testify to. So I need to file a motion for that.
Right, Judge, and I will need to respond.
If the court will allow. I know that we had motion cutoff dates already, but since the trial has moved.
I would think that since we're coming back to Mr. Hardrick, we could, if it's not too inconvenient for the people as well, we could return on that same selected date if that's available.
Or what? Just to
The 20, to see whether or not the report has been updated, been provided to.
I think we Okay, but I also think in September, we need to set a hearing date.
Okay.
So we can set an August to track, but let's plan on some sort of evidentiary hearing. I don't know exactly how this is going to shake out, but I don't want us to run up against a trial date.
Of course not.
again. So
I don't have my Dr. King's schedule handy. Is it possible if I could consult with him and then by way of email with the people as well, then select a date, because I don't want to pick a date that turns out to be, we have to adjourn it, et cetera, out. I should be able to get something to the court by the end of the day.
well, that doesn't mean, no, I'm gonna give you a date.
Very well.
And then he needs to try to work with it to the all extent possible, because I believe I'm probably juggling more than the doctor probably is, and I've already adjourned trial once.
Understood.
So, let's see. September 13th
That should be good for the defense.
at 1 o'clock.
So I have a trial that week and I hope I will be done by that day. I don't know though, because it's a pretty big case. Is there any way the court could do that following Friday, the 20th?
I'm supposed to be in a 7-day homicide.
Okay. Any day the week of the 23rd works for the people.
Possibly, and again, we're going down to the wire, but we do have enough time. We'll have a hearing and we'll have to figure out how I'll rule on it. Mr. Gozi, are you available on the 26th?
Yes, Judge.
Okay,
September 26th.
yes, that's going to be our hearing date.
Is there a specific time the court?
Yeah, we're going to do it in the afternoon. At 1 o'clock.
That's right.
And then let's set an August date. What date did Mr. Hartwick get? Was it the 21st?
Yes, Your Honor.
Okay,
August 21st.
can you do that? Yes. Okay, August 21st.
And that's a Wednesday, Judge.
Yeah.
I'm scheduled to start a trial on that date. I will obviously, I'm trying to resolve that matter,
Okay.
but I will let the court know sooner than later.
Well, if it's an issue, because again, we have so little wiggle room in this case, just come here first. You're here in the building, right?
Right. I am here in the building.
Okay. All right.
Come on, Mike. All set.
Also, thank you.
Okay, thank you. Off the record.
Thank you, Judge.
Worst case scenario, Judge, I can get somebody to stand in counsel.
Okay, yeah, that works too. No.
Second to last.
Oh, second to last. The 21st is for you days. No, so August 21st is.
Yeah. The family had it.
September date.
I haven't got a chance to. do it. I don't think it's-
September 26th at 1 o'clock is the evidence.
I can't just give.
Okay.
Without you guys going. through it, so.
Ms. Johnson, you are.
Mr. Davis. Your Honor.
Okay.
Do I have Mr. Davis step up, Judge?
Yes.
Yeah, I'm sorry. Wait, or for you.
Davis?
Right. I'm ready.
Calling case 24002786-01-FH. People in the state of Michigan versus Ryan Richard Davis. This case before the court today for a pretrial. Appearances for the record, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
And good morning, Your Honor. May it please this honorable court, Eric Gozzi on behalf of Mr. Ryan Davis. Could you state your name, sir?
Ryan Davis.
Okay, where are we?
Judge, I have filed a motion for return of some specifically property.
Yes.
And it was for specifically an Apple i15 Pro, white case, etc.
Right.
Well, after I filed this motion, the people indicated to me that their officer in charge perhaps was going to be requesting a search warrant. However, at this point in time, we still don't know if that has been requested or even been completed. So at this juncture, I would ask the court to grant our motion.
And Judge, if I may, I did file a written response to this. However, the phone is evidence in the crime. It's evidence I could honestly hold up at trial and use if I needed to. I don't think I'm going to be doing that. The extractions that came from the decoy officers that he was speaking to, as far as the charges are, is where I have kind of the screenshots of the conversation and those things. And so that's why we charged it without that extraction of his information. I did email my officer in charge this morning to ask him what's going on with that, because it has been a little while since I've heard back. I got a vacation out of office. It didn't have a return date on it though.
Okay. What's the return date?
It didn't have a return date.
Oh, it
on
did not have a return date.
And I do appreciate the people's concern on it. However, this case involves communications, two-way communications with a decoy and my client, all captured on both ends. And they've turned that discovery over. So what is the need for them to have the phone to say, aha, here's the phone he used? That would obviously be a little redundant considering everything else that's happened on this. So I would ask the court to at least turn it over, his phone over, so that he at least can access his email. That was one of the biggest concerns. Unfortunately, the way that, well, fortunately or not, a lot of people access their email accounts, their personal information, and use their phone as a computer. And unfortunately, a lot of email accounts have you set up a two-step verification process like Google that requires you to have your phone in order to verify that you are that person. So even if he was to try to remotely gain access to his own email account, he cannot, because it's been specifically placed with that phone. Therefore, Judge, in order for this my client to be able to conduct his affairs and get around with his life and have access to his email, he needs to have that physical phone in his possession.
Yes, something you want to say?
Judge, I'm still just stuck on the fact that the phone is evidence in a crime. And so
Yeah,
it needs to be turned over while the case is still active.
Right. So that's the court's position. So I understand it's a little inconvenient, but I have to make the best decisions I can with what I have in front of me. So the motion is denied. However, I was just more concerned because I think trial is October 23rd.
We have October the 23rd trial.
Right. And so I'll bring you back one more time. And if we still don't have it, because I don't want to run up against you, and you can give him a heads up, I will order him to appear to explain the status.
Absolutely, Judge.
All the time. So if that's what needs to happen, I'll sign an order and then he can come tell me on the stand what the delay is.
Understood, Judge.
Okay. August 21st.
That'll be our day together,
Okay,
Judge.
all right.
August 21st. It will be.
Okay, thank you.
Yep, and I'll be here.
All right, off the record. Well, let me ask this question.
So-
I already have it. I already have what's the offer.
Right, and we're obviously negotiating a better offer than that.
Okay. All right, anything further?
Not from the people, Judge.
Judge, could we have a different date? There might be something that would require his presence obviously would be required. Is it possible if we could have the,
Like what?
we'll do the 21st, Judge.
Thank you. All right, off the record.
Thank you, Judge.
Thank you. Oh, I'm sorry. Here's- I was just there. No motions.
I just had Mr. Johnson left, who is our violator, Judge. Did you want to wait till Capo is on?
Agent Mines, are you there?
We can recall this, Judge.
I'm here, Your Honor.
Oh, even better. Maybe not.
All right, and then after this one, I'm gonna do several FNS in a row, and then I'll come back to, I know Glenn has been here, so I'll come back. All right.
Johnson, could you step up, please? Thank you.
Jerry King.
All right.
Calling case 22-000523-01-FH. People of the state of Michigan versus Cedric Johnson. This case before the court today for review date. Appearances for the record, please.
Good morning, Your Honor. Agent Mines on behalf of probation.
And good morning, Eric Gozi on behalf of Mr. Cedric Johnson.
Cedric Johnson.
A little louder.
Good morning, Cedric Johnson.
Okay, thank you. Okay, Agent Mines, what's going on with the Oakland County case?
So we are, of course, we're tracking, and it has been adjourned again for another investigation discovery. And the next date is for August 6, 2024 for a review.
If I could shed a little light on this, Judge.
Okay.
As the court is well aware, and I think it's documented, he was referred to for criminal responsibility on that case. He did meet finally with Forensic Center back in June, just a couple of months ago. Now they're just waiting for the report. So they might say adjourn for investigation discovery, but I really think that the issue is they don't have the Forensic Center's report, which is scheduled for a return date on August the 6th. So I'm asking the court for its grace in allowing us to track this matter once again.
Any issues regarding his probation, Agent Mines? Recent issues? Clearly
No
there's
issues.
Okay.
No issues with Mr. Johnson.
Okay, I'll extend a little more grace, only because he's been tracking so long before I assume this docket, but again, that's not going to go into perpetuity.
We know.
It's just not. So, August 21st.
This is a repeat of today, down then. Excellent. We'll see you back on the 21st.
Okay, in person.
Yes, ma'am.
Thank you, Your Honor.
You guys have a good weekend.
Off the record on Johnson. Mr. Clerk, Your Honor.
We need Linda. She's not here.
Oh.
We'll get her.
Lisa, we good?
Mr. Glenn, who do you have?
Rayshon Rogers.
Okay, come on up.
Judge, could we approach about that first?
Okay. I have quite a few people in the waiting room as well. just so you know, For yours.
Okay. Mr. Clerk first, because he was here first.
Actually, Payne was here first.
Well, but Mr. Tyers.
Okay, hey. Well, clerk, she said clerk.
Yes.
I'm ready on Mr.
Okay.
Clerk, correct?
Calling case 19007131-01-FH. People of the state of Michigan versus James Clerk. This case before the court today for review date. Appearances for the record, please.
Good morning, Your Honor. Suzanne Samuels for the people.
Good morning, Don Johnson, Neighborhood Defender Services on behalf of Mr. Clerk.
And state tonight, sir.
Oh, James Clerk.
Madam Prosecutor.
Yes, Your Honor. Today, the people are moving to revoke the delayed sentence and send the defendant to probation for PSIR.
Okay, Mr. Johnson, I mean, I know that that's her prerogative, but is there anything you want to say?
No, Judge. My client has a number of issues right now, including homelessness and possible other issues, according to his wife, he's separated from, but is present in court with. Probation will probably have to sort this out, and I will be consulting with them during that evaluation process.
That's correct, Your Honor. It's my understanding the defendant needs to tender quite a few documents to probation when he goes.
Okay. Okay, let's set a date for sentencing.
Yes, Your Honor.
And I'll set it. Because we're starting to bump up against our move date. So you're comfortable because he's out. So like 4 weeks starts to, so it's gonna be after that.
That's
It's-
fine.
So it'll be September. September 13th.
Thank you, Your Honor.
Okay. So, Petey, do you have a map? Yep. Okay. All right, sir, you need to go to the probation department. You're being referred for a pre-sentence investigation interview. As part of that process, they're gonna ask you questions. They'll ask you for documents. So just give them everything that they're asking you for because they'll use that information to compile the report that I need. Okay?
Good.
All right, so you'll go there now. And I'll see you back on September 13th.
Thank you, Judge.
All right, thank you. All right, off the record on clerk.
Marcus Payne with Attorney General's on it.
Come on up. Payne.
Did you find it? I didn't find it either. Okay. I don't see it. Okay.
Calling case 170058640-01-FH. People of the state of Michigan versus Marcus Payne. This case before the court today for review date. Appearances for the record, please.
My name is
Paul
Marcus
Byer.
Payne.
Hold on, Mr. Byer, go
I
ahead.
apologize.
Paul Byer for the people. Good morning, Your Honor.
Lyndon Perkins Moore, NDS, on behalf of the defendant. State your name, please.
Yes, Marcus Payne.
Okay. Mr. Vire, have you seen these documents that I have?
Yes, I just sent everything to him.
Oh, okay.
There was supposed to be a waiver. My client has a copy of a waiver form of waiving the arrears. However, there's no entry with the court and there's no entry on his paper. It's not entered by a judge. So I don't know when it was taken or how. I don't have any notes in my file indicating when that was done because it would indicate that the arrears had been erased. My client also provided copies of all the state arrears that have been waived in this matters, and I presented copies of those to Mr. Vire. The only thing owing now, according to Mr. Vire, there's still an outstanding balance owed to the mother, the custodial parent, because that waiver, it's not entered, so that's still showing the amount. The other thing is he indicated that he has a payment that he's making toward the medical expenses because the state have all been erased. So at this point in time, Your Honor, I'm sort of in a quandary with no presented order, just a copy of an order that he has that's signed by the custodial parent, but there's no entry of it. So the balance still shows the same.
How long ago was this, you're saying?
When did you go to court with the arrears?
It was like 2 months ago. We went on Zoom call and you remember you had told me put my arms down because she was signing off.
No, I'm saying.
I'm trying to figure out go ahead, I'm listening.
Okay. But it sounds like there was another court proceeding that you're referring to. I was trying to figure out when that was.
Judge, if I might, Don Johnson, Neighborhood Defender Services. I'm looking in the notes and it appears that Mr. Presida appeared on February 23rd of 2024 and that there was a waiver of the arrears in the amount of $28,255.33. Mr. Presida says the order was signed by you. Now, if that order was never taken to the friend of the court, they would not have entered it. But it appears that it was in fact entered, and hopefully there's a copy in the court file.
Hold on, we're looking. Well, yeah. Okay, so let me just look and see if it's in Odyssey. That's the problem. I don't have the file, but yeah.
So my client does have a copy of it, but not the entered one. No, not the entered one.
Okay.
That's what my issue was.
Okay. February. Yeah, that's it. Okay, put that out. Okay, I have, here it is with a copy of the driver's license and everything from Ms. Jones. So do you want this?
Yeah, I'd like a copy of it, but I don't have an entered order. But anyway, what it would do is it would change the narrative in terms of the amount of the arrears. I believe it's right here indicating that the arrears are somewhere close to 30,000 now. That would erase most of it. And he would still have a balance, but he would still only owe the medical costs for the state.
Judge, may I weigh in?
Sure. Yes.
Thank you, Your Honor. The arrears figure I'm looking at as of last night, 35,363. There's two waivers. There's a state waiver from May 29th, about 9,300. That's already out. There's this court ordered waiver, the court signed waiver that's not been entered with the FOC. That's about 28,000. So We're talking about $7,500, $8,000 that this defendant owes to the state that cannot be waived. And he owes that money. In a very confusing case, not that I'm grading Ms. Perkins Moore, but she got like a B+ with no data. She got almost everything right except there's money, there's a little bit more money owed on this after all the waivers go through. So I think Mr. Johnson's right. We just have to get that, your waiver over to FOC and get this defendant on a path where he's paying on what remains with the state. But he's not paying right now.
Okay. So what are you recommending? Another review date?
Well, I guess I just through the court have a question. Is Ms. Perkins Moore represented he is paying? I mean, how much can he afford to pay on the state-owned debt up until when his probation expires? You know, $150, $200 a month, something like that.
You got a $50 payment now. The money order that he plans to tender to the court today. And then could you tell the court what kind of payments you'll be able to make?
Well, I'll be able to make $50 a month, Your Honor, because I'm already going for my disability. I have not worked in almost 2.5 years, and I'm trying to, as you see, I sent forms to you about my disability. I don't know if you got it in your system, but I had sent it to you, Your Honor, to your clerk. I made sure I did that the day I bought it out of jail, and I was hoping that you seen that I'm applying for my disability right now. And I have all my information as far as me applying. I haven't worked. And like I said, I was thinking that I can pay $50 a month on this, my back medicals bills, if that was possible, because I'm not working right now. I go to therapy and I'm for my hip and my knee. So it's like, I'm not working at all. So I haven't had no money. And if you could understand that I am trying to apply, I've been applying for my disability and everything is in the system where it's going on. They say my disability, she should be pop in after I'm 50 and I should be 50 next month.
Okay, hold on. So did you send it, what you sent to your lawyers? It shouldn't come to me.
I just told them.
Okay.
I just told them that no, we don't send anything to the law, to the judge. You send it to.
I send it to her clerk. Her clerk.
No, you don't send it to the courtroom at all.
Right.
I didn't know.
Yeah, no, it's fine.
Okay, I was just trying to make sure I got the information to you now.
I understand. All right.
Judge, I think I have a solution.
Okay.
I'm gonna move to close her probation without improvement.
Okay, no objection?
No objection.
Okay. Probation is closed without improvement.
Thank you, Your Honor.
So you don't have to come back, just keep making your payment.
Okay, Your Honor, and is there one more thing I can say? I'm gonna ask you first.
Okay, feel like you need to, I just closed your probation. What do you want to say?
No, I was just gonna ask, what I had put in a request about this teller box on me?
Oh, for the tether?
Yes, ma'am.
Okay, yeah, no, it's probation is closed without improvement. And so, yeah, the tether will come off.
Thank you,
So
ma'am.
stand by, have a seat. I'll draft an order for removal of the tether.
Appreciate you.
Thank you, Your
Okay,
Honor.
all right. Off the record on paying. Okay, Miss Samuels.
Can you call Mr. Burdine?
Okay. Come on up.
Judge, there's two Mr. Burdines, one AG, one state, or one county, I believe.
Okay, well, let's see.
I do show that he has a second case, the same Burdine, but I thought it was in Judge Knapp's with the Attorney General.
I have a nine, there's a.
It's been
Okay.
transferred, Judge, to you. Don Johnson, appearing on behalf of Mr. Burdine. You should have
Yeah,
both.
the 19 and the 21 case. Is that what you're saying?
Yeah.
Right? Okay, okay. All right. Okay, how both? Oh, you just gave me one file. Though.
Yeah, that's the only one we have.
Okay, you need to get the other one. Just make a note. You can call them both.
Calling case 19008605-01-FH and case 21000543-01-FH. People of the state of Michigan versus Derek Burdine. Both cases are before the court today for review dates. Appearances for the record, please.
Suzette Samuels for the people, Your Honor, on case 198605.
Morning, Your Honor. Paul Guyer for the Attorney General as to the 21 case.
Don Johnson, Neighborhood Defender Services, appearing on behalf of Mr. Burdine on both cases.
Okay, so what I have on the 19 case, because that's what I have in front of me, that probation was continued to November 18th of 2025.
That's correct, Your Honor.
Okay. Mr. Byer, so we'll start with you on
Yes.
on the 19 case.
Well, actually, Your Honor, maybe start with Mr. Byer, so then I'll know where I'm going, because I
Okay.
don't know what he's gonna say,
Okay.
so I'll wait.
Okay, Mr. Byer, what's going on with your case?
Judge, we've been at this a while with Mr. Burdine. If we start the clock on December of 23, a one payment of $800. The order is for $300 per month. On our case, $26,351 is owed. So I'd ask the court for a show cause at this point, or ask probation to show cause him. He's not paying his order.
Okay. Ms. Samuels.
Yes, Your Honor. And so I'm just gonna ask that my case, rather than requesting the show cause today, would be put on the same date as the AG show cause. I'm going to ask NDS to send me some documents that Mr. Burdine claims that he sent over. And so I'll have those ready when we come back on the show cause, Your Honor.
Agent Davis.
Good morning, Judge. Agent Davis on behalf of the probation department. I don't know if this changes how we're going to handle the 21 docket, but he's set to discharge on August 3rd of this year on the 21 docket. That's 2 weeks.
I'm going to ask the court to close probation without improvement on the 21 case.
And what was the date that you?
August 3rd.
I'll take that date.
Okay. Okay, so for the 21 case, then probation is closed without improvement. Okay, now on the 19 case, Agent Davis, again, he's extended on the 19 case to November 18th, 2025.
So Judge, rather than request a show cause today, I'm going to ask for a probation review. I'll get those documents. I'm thinking I may have to request a show cause when he comes back, but today I'm not going to ask for that.
Okay, when do you?
Actually, I think this is Mr. Johnson's client.
It is.
So if we could have that September 13th date, since his probation is through November of 2025, if that's okay with the court.
Okay, review September 13th.
Okay.
Okay, thank you.
Thank you.
Mr. Burdine, would you call me Monday afternoon, please?
Yes, sir.
Thank you.
Thank you. All right.
Thank you, Your Honor.
Clerk, do you have it? The 2021 case is closed, probation is closed without improvement. 2019 case, he has a date for September 13th. Another one missing.
Do you have Mr. Johnson, Virgil Johnson on Zoom, Your Honor?
I have a couple unidentified iPhones, and then unless I can verify who it is. Let them see. Who else? I have Mr. Pace.
Pace? Okay.
Orlando Pace.
Yes. He's on Zoom, guys.
And I have Mr. Baker.
I'm ready on page.
Judge, I'm so sorry to interrupt. Can we approach very quickly?
Yes.
Thank you.
Mr. Pace, we can hear you. Don't talk right now. So she
Okay.
calls for case.
Okay, thank you.
I'm ready on page.
Calling case 190004646-01-FH. People of the state of Michigan versus Orlando case. This case before the court today for review date. Appearances for the record, please.
Suzette Samuels for the people, Your Honor.
Linda Perkins Moore, NDS on behalf of the defendant.
Sir, unmute and state your name.
Orlando Pace.
All right.
Your Honor, this is a delayed sentence review. I see payments have come in May. We missed June. We have July. He's still cycling. I'm not going to move to revoke the delayed sentence today, Your Honor, even though the payments are short and inconsistent. We've extended his delayed sentence to September 18th, 2024, Your Honor. And we have a final delayed sentence review date on or about that date. And if he's not caught up at that date, then I'll move to revoke at that time. Thank you, Your Honor.
No objection.
September 13th.
Thank you, Your Honor.
Okay.
That will be revoking what? I'm sorry. Can I
Delayed
get an
sentence
understanding?
status. Give me a call, Mr. Pace. That means that you would lose, you would get a felony on your record.
Okay.
So give me a call Monday after 1.
Monday after 1. Yes, ma'am.
Yes, thank you.
Thank you.
All right.
You have a blessed day.
And Kenneth Barrett.
Okay, Mr. Barrett, unmute. Mr. Baker is not connected to audio, so Barrett is.
Okay.
No, Barrett, not Brett. Brett. Barrett. The F in this one.
Yes, Your Honor. Can you hear me?
I can, hold on one moment.
Okay.
Correct.
Calling case 07180, I'm sorry, 07-018442-01-FH. People of the state of Michigan versus Kenneth Barrett. This case before the court today for review date. Appearances for the record, please.
Kenneth Ray Barrett.
Is this the AG's?
Yes, I believe so.
Oh,
Yes, it is.
Mr. Byer,
I'm sorry.
Kenneth Barrett.
Well,
Kenneth
Paul
Barrett.
you cut out Mr. Byer. Do it again, please.
Fire for the people. I'm sorry.
That's okay.
Linda Perkins Moore, NDS on behalf of the defendant.
And Mr. Barrett, state your name.
Kenneth Ray Barrett.
Okay. Mr. Byer,
Thank you, Judge. I was waiting for my cue. He owes $37,916. He's paid $200 a month consistently this year, which is great, because that's the. We don't have anything in this month, but that's okay. He's got until the end of the month. So I'd ask for another review date. Or maybe if he can commit to us today, to continue this, no more review date, because he's paying.
Okay, just 1 second. Yes, that was a correction, I'm sorry. Ms. Perkins Moore, what do you think? We can have a review date or he can commit to an amount?
A review date, Your Honor.
Okay, these, Madam Clerk. Okay, Mr. Byer, how far out for the review date are you thinking?
October 11th?
Probably. Yes, I'm keeping it very light. I'm in a homicide, and I'm pretty sure it's gonna go, but October 11th, I can do it. I can do a few.
Thank you, Judge.
All
Thank
right,
you, Your Honor.
thank you. Off the record on Barrett. Okay, Mr. Baker is not connected to audio. I'm going to send him a. Mr. Williams, unmute. Justin Williams. Perfect. Mr. Williams, unmute. He may have stepped away. We'll see when he comes back because he was in the waiting room. Mr. Bland left. The case that you have in this morning.
Here I am, Your Honor.
Okay, turn your camera on. Okay.
I'm
Well,
sorry. I was heading to work for a meeting. I'm sorry.
No, okay, so I need you to pull over. Let me know when you pulled over.
I'm pulled over now. I was on the freeway. I'm pulled over now.
Okay, all right, yes. Party's ready on Williams, Justin. Ms. Perkins Moore, are you ready? I think it's yours.
That's Mr. Johnson.
Oh, it's Mr. Johnson? It says you, but that's fine. Mr. Johnson, you ready?
Well, I thought it was Ms. Perkins Moore's case.
Well, that's what it
Okay,
says.
well, I'll do it, Your Honor, but Mr. Johnson, you sent me the list and it's under your name, but I'll do it.
Okay.
I'm ready.
Calling case 1900661-01-FH. People of the state of Michigan versus Justin Williams. This case before the court today for review date. Pierces for the record, please.
Justin Williams.
It's like a recurring theme. Okay, hold on, Mr. Williams.
Okay.
Mr. Byer.
Judge,
No, your peers, Mr.
Paul Byer for the people. Mr. Williams owes 13,000.
Hold on.
Oh, I'm
Hold
sorry.
on, Ms. Perkins.
It's Friday. Linda Perkins Moore, NDS, on behalf of the defendant, and I apologize, Mr. Johnson, I was looking at Edwin Baker.
Okay, and Mr. Williams, now state your name.
Justin Williams.
Okay, thank you. Mr. Byer.
Paul Byer, for the people, 13,081 is owed, Judge. There's no current supports. Defendants paid consistently over the past several months, about an average of about $200 a month against that 13,081 obligation.
Sir, hold on 1 second. Sir, why are you looking around? It seems like you are moving.
I was wrong way on a one-way street coming off the freeway. I was just turning around. I'm sorry. I'm parked now. I was facing the wrong way.
If you ever do anything like that again, I'm going to hold you in contempt of court.
I'm sorry, Your Honor.
Mr. Byer, you were saying.
Defendant is paying consistently $200 a month. My records indicate the order is $400 a month. If we could hear from defendant why he's not meeting that 400, or if he can pay 300, money is coming in. There's not like no effort is being made. It's just not exactly what the court ordered.
Your Honor,
Hold on. Ms. Perkins Moore, do you have to say?
No, yeah, and I would like for him to comment. If he's making $200 payments consistently, but it's before, I'd like for you to address the issue of whether you can pay more, pay the 400 as ordered by the court, or 300.
I might be able to speak.
Yes.
For the last year and a half, my previous judge ordered my payments for 200, so that's what I've been paying. It was 400 before I started doing my court date, so my final judgment was 200. That's why I've been making 200, Your Honor.
That's fine, Judge. Can we just set another review date out in October 11th?
Okay, October 11th review.
Thank you.
Okay, thank you. Have a great day.
You too, sir. Bye. Off the record, Williams. Mr. Baker, unmute and turn your camera on. Mr. Baker. Turn your camera on, Mr. Baker.
Yeah, let's say next.
What did you say? Mr. Baker, is somebody in the room with you?
No, ma'am, I'm by myself now.
Mr. Baker, you're not telling the truth. Coupled with 2 times the camera came on and you didn't have a shirt on.
No, yes, I wanted to put my shirt on.
You should not turn your camera on. I thought, who's in the room with you? Who was in the room that said, hold on a second, bitch? I think that's what I heard.
No one's in the room right now, ma'am.
Who was in the room with you that helped you turn on the Zoom? Because we can come talk about it in person.
No, I turned my own. I've been waiting on.
Okay, so did you say it?
No, ma'am. No, ma'am. I didn't say anything. Ma'am.
Who else is Mr. Baker?
Yes.
Okay. All right. I'll see you in person, Mr. Baker. 1, you don't know how to have a shirt on before you turn your camera on. 2, I heard, as well as I think a couple of the people in the courtroom heard what they heard. But if you want to take the responsibility for all of it, that's fine with me too. So I'll see you in the courtroom on Monday morning. It might have been you. I don't know. I can't tell. I need to go back and listen to the recording. But let's just say, based upon what I heard, I'm holding you in contempt of court, and then we'll talk about what that penalty will be. I'll see you Monday in the courtroom. Failure to appear will result in a bench warrant being issued.
Well, what did I do? What did I do wrong?
Okay.
I don't understand what happened. I don't understand. No,
Okay.
no, I don't.
Okay, I'll see you Monday. We'll talk about it.
Mr. Baker, sign off. Give me a call.
I'll go back and listen to the recording. I'm pretty sure that's what I heard, but the fact that he turned his camera on twice without a shirt is reason enough for him to come in. But I'm pretty sure I heard what I heard when I was telling him to unmute, and coincidentally, I heard what I heard. So we're in a courtroom. We're just not gonna act this way. I will never compromise that, ever. So we have plenty of space for temporary residents in the Wayne County Jail.
Judge, whenever the court's ready, I believe,
And
Ms.
Shorty's
Birchbach
ready
and I
too.
are ready on Shorty. That's just an arraignment.
Okay, and then what about Mr. Picard's case? Because he's been here.
I'm also ready on that case, and we'd also be asking for, if the court would be inclined, the people are ready for immediate sentencing, and defense is fine with that as well.
Come on up.
Right here next to them. Yes.
Where's the your client's name?
Mr. Bird, Torres
This is
Bird.
Bird, right, and I did see from Ms. Broden that she did say the parties probably reached agreement.
Yes, we did, Your Honor.
Okay. Where's that file? And I need to see.
Is that true?
Yeah. Right, and thanks for the heads up for the immediate sentencing. Okay, Bird.
Calling case 24-003310-01-FH. People of the state of Michigan versus Torres Bird. This case before the court today for a calendar conference. Appearances for the record, please.
Elizabeth Kellogg on behalf of the people, P84687.
May it please court, Your Honor, Tyrone Baker, P number 62647, appearing on behalf of Mr. Torres Bird, who's present to my left, Junior, excuse me, who's present to my left, Your Honor. Good morning.
State your name.
Good morning. My name is Torres Jamil Bird Jr.
Okay, so today is the date and time set for a calendar conference, but it appears that the parties have reached resolution. Madam Prosecutor, please place the terms of the plea and sentence agreement on the record.
Yes, Your Honor, it will be a plea to an added count of assault and battery. That is Pat Code 75081. People will dismiss count 1, CSC 4th. There is a sentence agreement of 2 years probation, sex offender counseling and treatment if requested by probation, no contact with William McConnell, and any other conditions set out by probation.
What does that mean if requested by probation? Or if some, I don't know anything about the case, but.
I think, if I may,
Sure.
I think what they're indicating is just that they, for him to do an evaluation first, whether it be psychological evaluation, et cetera. I know it's not specifically indicated psychological evaluation. We would have no objection to a psychological evaluation. I would submit, Your Honor, that it's my belief at that time that Mr. Berg will not be asked to do that. But if he is by the court or by probation, he will certainly comply.
So here's what's gonna happen. It's kind of based upon the nature of the charge. I'm not sure what's going on here, and I want to make sure that the court is responsible in ordering what needs to be ordered. I am going to order a pre-sentence investigation report, and there isn't going to be immediate sentence.
Understood, Your Honor.
I understand, I appreciate it because I like to keep things moving along, but no. Okay, Mr. Bickard, other than what I just said, is that the accurate understanding of the plea and sentence agreement?
That is my understanding of the plea and sentence agreement, Your Honor. At the appropriate time, I would like to make a request as relates to sentencing from my client.
What's the request?
Oh, just that, I was gonna ask if the court might allow him to appear via Zoom. Mr. Berg did come from Canton today. He actually left his ship. I was gonna apologize to the court. That's the reason why he's as tired as he is, because he came straight from work. He started work at 5:30 this morning, Your Honor. He's had some transportation issues. Actually, had to catch a quite expensive Lyft or Uber this morning. And I'm just would ask the court to consider, if the court does not do immediate sentencing, if the court would allow him to appear via Zoom for sentencing.
About it.
Understood.
Other than that, is this a full and accurate understanding?
Yes, it is.
Okay, sir, is this what you would like to do?
Yes.
Okay, state your name and spell it for me.
My name is Torres Jamel Bird Jr. and it's spelled Torres. My first name, and then my middle name, Jemel, and then my last name, Byrd, and then I'm a junior.
Okay, how old are you?
I just turned 31 this week.
So as an aside, just a little joke, and I just don't joke here. He's still very young because I used to do that. I used to be like, I just turned, now I hang on to that year until the day of, like literally, like birthday is tomorrow. I am still the current age, so yeah.
Well, I laughed on it because I just turned last week as well. So I kind of chuckled when he said that because but significantly older than Mr. Bird.
Yeah, so that's funny. As he gets older, we'll see if he continues to do that. So in any event, how far did you go in school, sir?
I went to medical school.
I'm sorry?
I went to medical school. Like the last time I was in school was from fall of 2017 to spring of 2018.
And where was that?
Located in Ann Arbor, Michigan.
What school?
Ross Medical Center.
Okay, so you graduated from high school?
Yeah, I graduated from high school.
Okay, and you read, write, and understand the English language?
Yes, ma'am.
Okay, I'm going to ask you a series of questions. If at some point you don't hear me, you don't understand me, I want you to stop me, interrupt me so that I can in fact repeat the question or explain, okay?
Oh.
Having said that, if I ask you a question and you can answer, I'm going to assume that you understood my question and that the answer you gave is the answer that you intended to give. Do you understand?
Yes, ma'am.
Okay. For the charge of the added count of assault and battery, how do you plead?
I plead guilty.
Holding a form that sets forth the plea and sentence agreement in this matter. Is this your name on this form?
Yes, I signed it.
Okay, you did. This is your signature.
At the bottom, yes, I signed it.
Okay, all right. And did you sign this form after you had an opportunity to review everything fully and completely with your attorney?
Yes, ma'am.
Do you have any questions regarding the plea and sentence agreement?
No, ma'am.
Okay. Do you understand that by pleading guilty to an added count 2 assault and battery, you are automatically convicted of that 93-day misdemeanor? That's a tether. I know it's a tether.
It took me a minute, didn't it?
Okay, again, do you understand that you are automatically convicted of that 93-day misdemeanor and are agreeing to 2 years probation, as well as sex offender counseling and treatment, no contact provision, as well as any other terms and conditions set by the court?
I understand.
Okay. Any questions about anything I just said?
No, Your Honor.
Do you still wish to proceed?
I think so.
No, I think so. Do you still wish to proceed?
What is it?
She's asking whether you want to continue to move forward with the proceedings after everything she asked you.
Oh, I understand. I understand everything that you.
Okay, I understand that you understand. So now my question is, do you still wish to keep moving forward?
May I?
Yes.
What the judge is asking is, she's covered some things, she's asked you some questions. And after all those questions, she just wants to know if you want to continue with the plea and with what we're doing here, or whether, because of everything that she's been asking, whether it's, you have a concern, you say, no, I don't, based on what you said, I don't, I want to stop. Or do you want to proceed forward?
Oh, yeah, no, I don't have no concerns.
And you still wish to proceed? The answer is yes or no.
Yes.
Okay.
Yes.
All right.
Yes, moving forward with it.
Thank you. All right. So by electing to plead guilty today, you're waiving a number of important rights that you would have if you were to proceed to trial. Those rights are listed on the form that your lawyer went over with you, but I still go over everything with you on the record to make sure that you understand. Do you understand that you have the right to be tried by jury?
Yes.
To be presumed innocent until proven guilty?
Yes.
To have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes.
Do you understand that you have the right to have witnesses against you appear at trial? Do you understand that you have the right to question or cross-examine those witnesses through your attorney?
Yes.
Do you also understand that you have the right to have the court order witnesses to appear on your behalf?
Yes.
Do you understand that you have the right to remain silent during trial?
Yes.
And that that right cannot be used against you?
Yes.
In other words, if you decided to proceed to trial and not testify, I would instruct the jury that they cannot use your silence against you in reaching a verdict. Do you understand that?
Yes.
On the flip side, do you also understand that you have the right to testify on your own behalf if you chose to do so to tell facts?
Yes.
Okay, do you understand that by pleading guilty today that you're giving up all the rights you just reviewed?
Yes.
Other than the plea and sentence agreement placed on the record here in court today, has anyone promised you anything so that you will plead guilty?
No, Your Honor.
Anyone threaten you or force you any way to plead guilty today?
No, Your Honor.
Do you understand that if I accept your plea, you will be giving up any claim that your plea was the result of a threat or promise unless you tell me about it right now? Do you understand that?
Yes, I understand.
Are you currently on probation or parole?
No, Your Honor.
Do you understand that by pleading guilty that you are giving up the right to appeal your guilty plea as a right? And even though the Court of Appeals may grant you leave to appeal, it is not obligated to do so?
I understand.
Do you understand that if your plea is accepted, that you may be giving up the right to appeal issues that otherwise will be appealable to you if you were convicted at trial?
I understand.
Sir, please tell us what you did on or about May 19, 2024 at or near 30325 Flynn Drive in the city of Romulus, County of Wayne, that makes you think you committed this crime?
I put my hands on a stranger that I did not know.
Okay. When you say put your hands on a stranger that you did not know, what did you do?
Like physical touch.
Okay. And 1 second. And you said that you did not know. Did you have consent to touch them?
No.
Okay, Madam Prosecutor.
So I'm sorry for interrupting the court. I thought the court was finished. And Your Honor, the people are satisfied.
Defense is satisfied, Your Honor.
Okay, the court finds that the plea is understanding, voluntary, and accurate, and will accept the guilty plea. I am going to refer it. And so we'll set a date for sentencing. One moment. Is there any objection? This is a misdemeanor, so I am requesting a plea because I do want to know more about this, just based upon the responses I got to the court's initial questions. So, any objection for the request for him to come on Zoom?
None from the people, Your Honor.
So I'm going to say that that's okay. If I read something and I think it's concerning, then I'll say no. But as it stands right now, and it's the answer is yes. He can come on Zoom.
Okay, understood, Your Honor. So if the court has a concern, the court will let me know and I'll let my client know he needs to go
So
first.
unless you hear something different on Zoom.
Thank you, Judge.
Okay. And I'll actually even do this about 6 weeks out because it's been instead of the 4 weeks. So let's see.
Your Honor,
Yes.
I understand what the court just stated. I'm sure the court has its reasons.
You want it sooner?
I would, because Mr. Byrd is trying, he's recently got a promotion, and we're trying to clear up his record, what it is and what it isn't, so that we don't have any issues with that. And so we'd like for everything to kind of go through. I mean, I guess after today, it really should be resolved. I mean, there's going to be a judgment entered. I just would like, we're just trying to wrap it up as fast as possible.
But the problem is we run into our moves.
Okay. Oh, I understand. Okay. I understand. I understand, Your Honor.
I mean, is this a problem with his job or not? He has a
Well,
job.
well, as of right now, Your Honor, I mean, they have indicated they want to do a background check and in conjunction with him receiving a promotion. And so his initial charge is different than what he's pleading to. And we would just like it, we just wanted to make sure that it was reflected of what he's actually, you know, which I think it will be after today. I mean, after today,
Right.
so I will follow up. He'll let me know and I'll follow up, but
Here's what I'll say, because I wouldn't schedule it until September 9th. If it becomes a problem, and it shouldn't, because again, this will be scanned and entered and he'll get a copy of it. If it becomes a problem, maybe I'll be comfortable after I look at the police report or something. I just don't know enough about it. And again, I wasn't really comfortable with the answers I received.
with the court, if the court were inclined to consider immediate sentencing, would the court like a copy of the investigator's report?
Yeah, you can let me take a look at it. But I wouldn't do it right now, so.
Oh, okay.
Yeah, I have some other cases to file,
Oh,
but I might not refer it, I guess is what I'm saying. If I'm just confident enough that what's proposed here is covering everything.
Maybe I could just have Mr. Burke come in on a different day or,
Yeah, I'll look at the investigator's report.
okay, I can provide that.
So I'll hold off on referring it and I'll let you know next week. So let's calendar it for next Friday on the 26th. Can you do it?
I can, if the court allows me to do Zoom, Your Honor.
Yeah, that's
I'm
fine,
leaving
because-
out of town Saturday morning and I gotta,
That's fine. Because either I'm gonna tell you, and I probably will be, once I know more about the case, that I'm imposing any conditions that I think could be,
okay,
the people know more about the case than I do. So I'm assuming that everything is covered, but I just want to make sure based upon the
I understand.
charge.
I understand, Your Honor. That's-
So I'll put it back on for next Friday. And at that time, plan for sentencing.
Does Mr. Burke need to appear?
No, he can come on Zoom.
Oh, on Zoom, appear on Zoom
Yes,
though. Okay.
because again, plan for it to be sentenced.
I just wanted to make sure even that I knew whether he needed to be.
Yes.
Okay,
Yes.
okay.
Okay.
All right, thank you.
So the answer is I'm putting it over for sentencing for next week.
Understood.
Okay, and then she's actually gonna print out the investigative report for me right now. And then I'll put it in
Oh,
the file and
okay.
I'll read it. But okay, all right, please accept it. That's all squared away. If he wants to get a copy of this after it's scanned in, do you want a copy of this?
The plea form?
Yes.
No, I'm gonna give him this copy right here.
Okay, all right, thank you.
All right, thank you.
Off the record on Bird. So the RDB. Wow. Okay. Yeah, well, Mr. Glenn, I think he's been here like all morning and then Shorty. So Rogers, where's Mr. Rogers? Okay, Rogers and then Shorty. I still have Rogers. I do. Okay. Have we seen Miss Wilson? Or Mr. Banta? No?
Will the court be issuing a capias for Ms. Wilson today?
I don't think so because
Oh, no, why?
we think it's a slim chance that she may have been given the wrong day.
Okay.
And she's even shown up on days when she didn't have court.
Yes.
So I don't think I would be inclined to issue a capias.
Okay.
Yeah, but we'll call it and try to. Okay, Rogers, come on up. I am ready.
Calling case 24-00-2261-01-FH. People of the state of Michigan versus Rayshawn Rogers. This case before the court today for a final conference. Appearances for the record, please.
Elizabeth Kellogg on behalf of the people, P84687.
William Glenn, P 36794 on behalf of Mr. Rogers. Sir, state your name.
Rayshawn Rogers.
All right, where are we?
Your Honor, the people did tender a new plea offer today of disorderly person. The people would then dismiss count one. There is a sentence agreement of 1 year probation on that. It's my understanding defense counsel would just like a little bit more time, as it was just tendered today, to go over that with their client.
That is correct, Your Honor. I don't want to push my client in a decision that, he may, may regret later on. So we would ask the court for a couple of weeks for him to think about it.
Okay. August 5th.
Is the 6th available, Your Honor, or the August the 2nd?
The 2nd is not, but the 6th is.
Okay. But maybe we have the 6th, Your Honor.
August 6th.
Great.
Okay, and so the answer to the question off the record to adjourn, I don't know yet. But I'll let you know the 6th.
Understood, Your Honor. Thank you.
Okay. Because a lot of that depends on what happens with those other cases and depends on how the age of the cases. I have to look and decide who I think that, the priority would be. But yeah, I'll let you know.
Thank you, Your Honor.
Okay. Thank you. All right, off the record.
New shorty.
Yes.
Try to call Mr. Banta to see.
Sure.
Judge, I think there were various people trying to log on to the Zoom for Mr. Shorty, potential his employer. I think his first name is Dre. I don't know exactly what his full name is.
And who are the other people?
One of them is named Nyla, but I don't know if she was logged on. So I think it's primarily someone named Dre. If there's someone logged on under that name.
Not, but we'll see. Okay. There's some unidentified people.
Okay.
So. All right, let's call Shorty.
Sure.
All right.
Calling case 24-003910-01-FH. People in the state of Michigan versus Clifton Shorty. This case before the court today. What arraignment on information appears for the record, please.
Elizabeth Kellogg on behalf of the people, P 84687.
And Charlotte Birchbeck from the Neighborhood Defender Service, P number 86740 on behalf of Mr. Shorty.
Okay, your name, sir.
Clifton Terrell Short.
Today is the date for an arraignment on the information. As to reading,
We would waive formal reading of the information and stand mute as to the charges.
the court will enter not guilty pleas on all the charges contained in the information, which contains a habitual offender fourth offense notice. Does the defense acknowledge that?
Yes, Your Honor.
Okay. Is there any offer on this case? What's going on with this?
I think I need to complete a gun board letter, Your Honor.
Okay, that is correct, Your Honor.
And so I've started on that. I will get it to Ms. Kellogg as soon as possible. And I also anticipate filing a quash and a motion to suppress in this case. So I'd ask that the the transcript be ordered.
Okay, so we'll set a trial date and everything and a final conference date and all of that. I've looked at his file. Now that I have it, I'm not modifying his probation bond. And that's why I've never rushed to make a decision. I didn't realize he was habitual before, and I thought it was just gun, it's resisting obstructing, it's over container vehicle, like all of this. So based upon that alone, I cannot find that, and I was thinking about it and I was unsure, but that's why I always wait and see. So I'm not gonna keep calling you back down here. I'm not modifying the probation bond as it stands right now.
I understand Your Honor's ruling. I just want to, for the court, because they've been here all morning, I just want to make a record that his mother is here again. The person who was in the car with him, Letitia, is here again. And then also a family friend, Mr. Rashawn, is here as well. They're all here in support of him, and his employer, I believe, was trying to log on to the Zoom to assure Your Honor that he is in fact employed, understanding that yes, those are the charges. He does have a habitual fourth notice on here. That said, as I've indicated about the case before, we'll be contesting that he had any awareness that the guns were in the car. And yes, there is also the resisting. And in terms of that, Your Honor, that's part of what we'll be submitting mitigation for in the gun board letter as to Mr. Shorty's, some of his mental health difficulties and what may have precipitated the alleged resisting in this case.
Okay.
That said, Your Honor, I think he has a personal bond on the open case. If Your Honor is not entertaining reducing bond on the probation matter, I'm going to ask for nominal bond on the probation case or on the open case so that he gets time credit.
Okay. So you want me to increase it to what?
So I haven't done this before in this jurisdiction. Do you know what the amount is that will give him time credit? I would ask for $100 at 10%.
I think $100.
Okay.
So so bond is increased on this case to $100 from personal bond.
And I also, Your Honor, wanted to just, on behalf of Mr. Shorty, apologize. In court earlier this week, Your Honor noted that you perceived him to be making some faces. It was not Mr. Shorty's intention to be making any faces, Your Honor. I think he's just feeling frustrated with himself in the situation and just wants to get out of custody, but did not intend to do anything that would insult Your Honor.
Yeah, no, it's not. I mean, I said it and he said he didn't realize it. I moved on from that. That's not what it's about. Like I said, I have to do balancing up here, and I appreciate the family support and all of that, but I have to make certain decisions up here, and they're, tough calls every day. He could be at remand on the probation case. He's not. I could say he's gonna have a violation hearing right now. I haven't said that. So this is my way of, I think, balancing. And if at any point in time you want a violation hearing, then I would honor that request.
Understood.
All right. So, Madam Clerk, order the transcript. I think she's doing that right now. That's gonna be 5 weeks from today.
Okay.
If we're lucky, so.
And I will have a quash prepared shortly after that. I'll just be able to plug in the transcript. So I just ask for a date sometime after the transcript is available.
So we're looking at the end of August. This is into September. Let's set a trial date and then we'll think back into the rest of the dates, and if we don't need the trial date for whatever reason, of course, we can take it off. What did you tell me about your availability?
How far out is the court going for trials? I have some judges.
Probably October.
Okay. Yeah, my October is fairly open. The week of like the 14th would be good. The week of the 14th would probably be best.
And that is not
good. Okay. In that case, the week prior, the 7th would work. So I don't know how many days we're looking at for this. I would imagine it would just maybe be 2
days.
Yeah.
Okay, October 7th. You know what? If we have to, I don't know. I'm between the 7th and the 30th. Are you available on October 30th?
I am.
Okay. So now let's see how this is going to go. We're, in essence, give or take September, the first week of September. Transcripts is coming the end of August. So if I say it's due on the 23rd, you're saying you don't need much time after it comes in?
I was there, so I'll write it without it, and then I'll just make any corrections I need to.
Okay, so if I say filed by the 6th, responses by the 16th, and I'm in September. And then we'll have our final conference. Okay, let's have the trial on October 30th.
Do you October 30th?
Yes, instead of the 7th?
I thought you said September 30th.
No.
Oh.
No, it's between October 7th or October 30th.
Oh, I thought you were going earlier. Okay, October 30th.
Judge, at the final conference, is that where you'll be deciding if defense counsel does indeed file a motion to suppress whether an evidentiary hearing is warranted?
I'm thinking about, based upon a representation, and I believe that she's going to file it, and testimony is likely going to be required. I think I'm going to set the date now.
Sounds good.
Because I can always take it off. So I'm just trying to line up all the dates. So October 30th is going to be the trial. 8:30. And then Madam Clerk, look at October 4th. Do I have the evidence here? Thought I have one, but I took it away. Okay, October 4th for the evidence here. That works. Okay. So now we've nailed down all of those dates. Do we want to come back for a pretrial?
I would like to.
Okay, how far out? 30 days?
Sorry?
30 days?
That's good, yes.
I can do the 16th. It's a little less.
The
or-
16th.
The 16th is good?
Yes.
Okay. I mean, I do believe you're diligent, so you'll get your gun board done and we'll see where we're at. August 16th for pretrial. Okay, let's repeat all those dates back. Make sure everybody's on the same page.
I have a motions deadline of September 6th. What I'm putting in as a final pretrial on August 16th. And then we set the trial date for October 30th and a evidentiary hearing on October 4th.
Yep, and responses to motions are
The September 13th. And Judge, when will we be arguing the quash then? Or would,
probably on the same day.
on the 13th or on the October 4th?
Probably on the 4th, but if I change my mind, I'll let you know.
And Judge, I do just want to state on the record, presumably, there will be a gun board offer, hopefully, before September 6th. But the gun board offer will expire on September 6th, the day that the motions are due.
Could it expire at the final pretrial on the 16th?
September 16th?
I think we set a final pretrial conference for August 16th.
August 16th, correct.
That
You
would be
want
a
it to
day we
expire
could take.
sooner?
That's, no. Oh, what day are you
I
saying?
would
it
say
expire?
September 6th, the day the motions are due.
Oh, okay, yes, that's fine. I don't want it to expire sooner.
No.
Okay, thank you all.
Thank you.
Thank you.
Thanks.
Thank you very much.
No, file by September 6th. I do write it down, but you have to do that. Like, file by September 6th, responses, I actually said by the 16th.
Yeah.
Correct. Correct.
Oh, okay.
She left.
I know what it is.
No, I just wanted to finish this note. Hey, Mr. Harris.
Hey.
Long time no see.
Yes.
Too long.
That's the.
What's going on?
Sherry.
Good news. I'm Mr. Phillips.
As long as you have those.
Are you referring to the email that he's ineligible?
No, I'm not. Is he ineligible?
Yeah, you didn't see the email?
I did not see the email.
Yeah, he's ineligible because he has
you
like homicide-ish conviction.
Yeah, he doesn't.
Yeah. So he can plead and charge one, no sentence agreement. Well, I mean, she kind of has to statutorily.
Okay, I
25,
think,
says 1.5.
well, she's not ready just yet.
Oh,
Ms. Samuels, who else?
yes, we have Mr. Reeves here, Your Honor, and
Okay.
Mr. Jones after that.
Okay, Reeves,
Your Honor, may I add something?
sure.
Will we be doing anything with Michelle de Guzman today?
No, I put it over to next Friday.
Okay. Okay, well, thank you so much. I will see you guys. Enjoy your weekend.
Okay, thank you, you too.
Bye-bye.
Okay, you said Reeves.
Yes, please, Your
All
Honor.
right.
Next Friday, which is.
So that's my plan. Mr. Burgess.
Yeah.
It's my plan. All right. Reeves is FNS. This is not an actual sentence.
No, Your Honor, no,
Double check.
not on this one.
I didn't think.
If that's okay.
No, it's fine. That wasn't my recollection. I was just double checking. Okay, I'm ready.
Calling case 1-800-7713-01-FH. People in the state of Michigan versus Damon Reeves. This case before the court today for citizen appears for the record, please.
Suzette Samuels for the people, Your Honor.
Linda Perkins, more NDS on behalf of the defendant. State your name, sir.
Damon Reeves.
Step up.
Damon Reeves.
Your Honor, rather than move to a sentencing in this matter and create a permanent criminal record, which would require the defendant to report to probation, I believe the defense is respectfully requesting one more adjournment of the sentencing. I have no objection to that. Mr. Reeves is here with a payment in hand today. And after speaking with defense, there's an issue that I am going to check out for them regarding the custodial parent. So we may have a date, Your Honor. I believe September would be good. I think the PSIR is good through at least October.
At least, I think it was
Yes.
April. if I recall
Yes.
correctly.
And I would rather check that issue out first, Your Honor, because it could be dispositive.
September 12th.
Sorry, Your Honor.
September 12th.
Thank you.
Okay. Thank you. We're off the record on reading.
Thank you, Your Honor.
Thank you.
Mr. Reeves, make sure you appear on time, 9 o'clock. 9 o'clock.
I was here teaching.
Okay, 9 o'clock. No, I've been calling my name. You wasn't here, so let me try it. Okay, bye.
We're ready on Mr. Jones.
I'm
Your Honor.
sorry,
He-
guys.
He's not on the docket.
So sorry.
I'm sorry. He was supposed to be here yesterday, but he thought it was today.
Okay,
I didn't know he was here until a few minutes ago.
so we need his case number.
I have the case numbers.
Okay, let's add them. He's just for review?
Actually, he's at final conference, so we're gonna have to set some dates.
Yes.
Can I have the case number, please?
Yes, the case number, there's two of them. They are 227421 and 227426.
First name.
William?
I do. It would have just been from yesterday. Is he a more status? He might be.
You know, I don't know if I asked for capias or not
I want
yesterday.
to say, so looking.
Probably I did.
I think so. Look in the warrant drawer, if not looking yesterday's date, which is behind 18. One of the
Yeah, I'm sure I did, Judge. When I'm looking down at the posture of these cases, I'm sure that I did.
I think so. So just hold on 1 second. Mr. Roberts, I was looking at my watch. You made it.
Thankfully, Judge. Good to see you.
Yeah. You made it. You still had quite a bit of cushion. I saw when you out there. Where did you find it? Okay, are we ready to call it? And I
Yes,
think
that's fine.
he's
Got
in
two.
warrants, once she pulls it up, because I think he might be in warrant status and we'll recall the case.
Ready for me to call?
I am.
Calling case 22-00741-01-FH and 22-0074260-01-FH. People of the state of Michigan versus William Jones. These cases are before the court today. Looks like for failure to appear. Appears for the record, please.
Suzette Samuels for the people, Your Honor.
Linda Perkins Moore, NDS, on behalf of the defendant. State your name, sir.
William Jones.
Okay, so his hearings were yesterday, so the court did issue KPS. However, he is here today, and it's one day he walked in on his own. I don't need to explain further that he got the days mixed up. I believe him. So, Madam Clerk, recall those warrants if he did 2 separate warrants of the cases. All right.
Your Honor, these are final conferences and I cannot offer a delayed sentence today. We're going to ask the court for another final conference date. And if you have to set a trial date, Your Honor, that's, I understand. But we may be able to resolve this at the next date.
Yeah, no, I'm not gonna set a trial date.
Okay,
We will
thank
reset a
you.
final
Okay,
conference date.
thank you.
How far out?
I would say,
Next
if we do September, that would be
Oh,
good
September.
because it's my understanding he's going to start making some payments. And so that'll give time for them to post. And it's also my understanding that he's filed motions for modifications. So I'll be able to check that out.
September 11th.
Thank you, Your Honor.
No, that's a Wednesday straight.
Oh, okay.
September 10th.
The 10th, Tuesday, the 10th.
Okay.
Off the record, one Jones.
Thank you. I apologize.
Okay, we'll see you back.
Is Seismoniac on the docket? I don't see him on my docket, but I see him in the waiting room. And I remember the name.
That's an AG.
I was gonna say, for some reason,
Yeah.
I think it's an AG.
It is.
Okay,
Yeah,
okay.
I don't see him on the docket. Let me check.
Alright. Okay, who's that back in the back? In the gallery? I always confuse everybody. You ready on King? Was that
I think that's,
Mr. Byer?
it's AG. Yes, Your Honor, it's AG.
I have Mr. Little and Mr. King left, Judge.
Mr. King is here.
Ready to go.
Mr. Johnson.
And I have Torres as well.
On Zoom?
Mhm.
That's Don Johnson.
At 11:51, he joins us. He just popped up.
I always say to my daughter, I don't start my day at the crack of noon.
Okay,
King.
King.
Calling case 04-01-8887-01-FH. People of the state of Michigan versus Jerry Dwayne King. This case before the court today for review date. Appears as for the record, please.
Morning, Your Honor. Paul Byer for the people.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. King.
Mr. King, state your name.
Jerry King.
Okay, probation was extended to February 14th of 2025 with an order to pay $150 a month. That's the last order I see in here. Mr. Byer?
That's right, Judge. Big number owed, 109,171. But if we start the clock in April, he's consistently paid what's ordered. I paid 300 last month. I don't know if he doubled up for this month. He's going to pay this month. I don't know. The order is 150. He's making that. It asks the court for another review period out in October, the 11th or the 18th.
Join in that request.
October 11th.
Thank you, Judge.
Thank you.
Okay. Your return date is October 11th. Torres is the AG.
No, that's mine, Your Honor.
Okay. Mr. Torres, unmute. Unmute.
Hello.
So where have you been all morning?
I've been trying to log in, and I went to the wrong courtroom.
Okay. All right. I'm ready.
Calling case 17-002857-01-FH. People of the state of Michigan versus Enrique Torres. This case before the court today for review date appears for the record, please.
Suzette Samuels for the people, Your Honor.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Madrigal Torres.
Sir, state your name.
Enrique Madrigal Torres.
Delayed sentence?
Yes, Your Honor, and we've already extended it to November 10th, and the defendant is in compliance. He's been in compliance on this since at least April. And if we could have a delayed sentence review date in September, and if he keeps going like this, I expect we'll close this case out on the final delayed sentence review date. I think he will, Judge. He has a lot at stake. He's not a citizen.
Okay.
Do we have September 20th, Judge?
Yes, yes. I'm in trial, so I'm keeping it light, but yeah, the 20th is okay.
Thank you.
All right. So your next review date is September 20th.
September 20. Okay.
Okay, thank you.
Thank you.
Thank you.
Ms. Samuels.
Right, who did they have on Zoom? I have Mr. Johnson left.
I have two unidentified.
And
Virgil Johnson is on Zoom, Judge. He's probably one of those unidentified numbers.
Well, parties need to learn to figure out how to put their name. But let's see. Okay, I think he might, okay. So when you pulled over, then. Sir, I need you to unmute and tell me your name. Mr. Johnson, is that him? No.
I think it is, Judge. I believe that's Virgil Johnson.
Okay, there we go. There we go.
Are you Mr. Johnson?
Yes, Your Honor.
Okay, very good. All right. Let's go.
Calling case 03-018116-01-FH. People of the state of Michigan versus Virgil Johnson. This case before the court today for review date. Appearances for the record, please.
Suzette Samuels for the people, Your Honor.
Don Johnson, Neighborhood Defender Services, on behalf of Mr. Johnson.
Mr. Johnson, state your name.
Virgil L. Johnson.
All right.
Your Honor, today the people are going to request a show cause in this matter. When we were here in May, the defendant indicated he wasn't working because he had a recent car accident. And so I'm waiting for those medical documentations, but I've been waiting, but he can tender them to probation now, Your Honor. I'm requesting a show cause and I've already contacted Agent Davis and we're just waiting for your permission with that.
Judge, Mr. Johnson has sent me those medical verifications. I'm just waiting for him to fill out the HIPAA release and return that to me before I can share that with Ms. Samuels.
Does that change your mind?
No, not in this case.
I didn't think so.
This is like the fourth time.
Okay,
that
and
I've
then
been-
we'll see what happens on the day of. I
Yeah.
have a feeling that you'll have it
Right,
and then.
Right,
it
and
will-
I'm assuming the vehicle he's in is maybe not the one he was in the car accident.
Okay,
Thank
so
you.
I'll put it on the docket for a show cause. I'll set the date now and then with the expectation that he'll be arraigned on it if it comes to that, on that day.
Thank you.
Okay, so let's see when that's gonna be. So Mr. Johnson, you need to sign that HIPAA release form.
Yeah, I
Before you
will. I
come.
just received it.
Okay, all right, very
And
good.
it's not against the law to have two cars, is it?
Mr. Okay.
I apologize.
Now I'm gonna say something back in response. I mean, yeah.
I mean, I'm just asking the
I'm just
question,
looking
Your
at-
Honor.
Mr. Johnson,
No,
Mr.
don't try to
Johnson,
be
don't
funny.
argue.
Yeah,
Okay.
don't try to be funny, especially when you're before the court on, back child support. Then maybe I do start to look at your ability to pay because he does have two cars. So don't go there. You don't have to respond to what she says because that'll tend to get you in trouble with me. Just respond to what I say or what your lawyer says.
Yes, Your Honor.
All right, let's see. August 9th.
What date, Judge?
August 9th. Are you available on August 9th?
No, I'm
that too-
gonna be, I won't be available that date, Judge. I'll be available the following week.
I'll have to go a little further than that.
Okay, you want it further out.
Yes,
Okay.
please. And that will give plenty of time to get all that stuff
Then I'm
together.
gonna do it past our move.
Okay.
So we'll go into September, which
Okay.
is giving him more than enough time.
Sounds good.
September 13th,
Thank you.
okay? All right, September 13th for the show cause in the courtroom. Well, does it matter? It's just the arraignment. It will be the,
That's okay for the arraignment.
yeah, okay, September 13th on
you
Zoom
know.
is still fine.
Thank you,
I was
Judge.
just looking at my other notes from other days. So again, I apologize for that.
Yeah, Mr. Little.
What's that?
Mr. Little.
No.
Sir, do you have it? Did you hear me? September 13th.
Yes, I heard you, Your Honor.
You're all
Okay,
set,
thank-
Mr. Johnson.
All right, thank you.
Bye. Agent Davis, did you get that?
Yes, I did, Judge.
Okay, perfect, thank you. All right.
Pretty simple.
David, how are you?
All right, they're both here. One is the plea and one is the sentencing. Who else do you have?
I have Mr. Russell is the last one that I have on the
Well,
list.
and I'm reluctant to let the Zoom user in because people like to do inappropriate things,
Right.
but I'll see. If that's the worst thing that happens,
Oh, get another one of those.
ridiculous.
Right, yeah.
It's not-
That's the only one I have
it's not
left.
depressed.
And I don't want to enter KPS. If
Right.
that's, okay.
Or safe.
Okay. Sir, unmute
His clothing out. It's a good sign.
and tell me your name.
Sir, you have to click on that little red microphone with the line going through it.
There we go. Sorry about that. First, I'm using iPad with this.
Okay, what's your name?
Robin Little.
That's mine, Judge.
Okay.
I think that's mine, Your Honor. He wasn't here. I don't know. He's on the list. Is he? Oh, yes. Okay, ready.
Okay.
Calling case 15-001894-01-FH. People of the state of Michigan versus Robin Patrick Little. This case before the court today for a review date. Appearances for the record, please.
Afternoon, Judge. Paul Byer for the Attorney General.
Linda Perkins Moore, NDS, on behalf of defendant.
Sir, state your name.
Robin Little.
Mr. Byer.
Thank you, Judge. $24,337 is owed. The current support obligation is $113 per month. Judge, we were last here in May, early May. Defendant was compliant at that time. He's paid as ordered the last 2 months. He's got 113 in this month, but not the 300 on arrears. I expect he's going to make that payment before the end of the month. We'll have to ask him. But I'm asking for another review date. That October 11th date look good for the other two.
No objection, Your Honor.
Okay, October 11th for the next review.
Thank you.
All right.
Thank you.
Take care, Mr. Little. Off the record
Right.
on Little.
Thank you, Judge.
No problem. The last person I have, besides Moniac, Mr. Byer, I think that's yours. And then I have the two in the, I have a plea and a sentencing of the court. All right.
Judge, I did not have him, but I can be prepared. I can be
You
prepared.
don't have, he must have a wrong date. Yeah, what is
I think he's next week.
next Friday?
I believe. I do not have him on my doc. Odyssey.
We don't either.
Judge, I looked in my database and I did have him for today, but I'm sure
Yeah,
he can come back
him.
next week.
Yeah. Sir, unmute for me.
Can you hear me?
I can. So some of us had you on the docket and some of us didn't. So we're gonna put it over to Mr. Yeah. So what about next Friday? Can we just do it next Friday?
Judge, I'm off next Friday. I've got one that's on the docket that I'm gonna ask the court to move. If the court could indulge me just a couple of minutes, I can pull this up. I think he's up to date. I don't know. Or we gotta go out 2 weeks.
It doesn't matter to me. We can add them. I guess it's okay to add them if you're not going to, if it's not going to be controversial, but well, Mr. Johnson's ready for him. So yeah, go ahead, Mr. Byer.
I just need a minute to pull up his account, Judge.
Go ahead. And then in the courtroom is gonna be Collins, followed by Benson.
Phillips.
Oh, where did he go? Where'd Mr. Harris go? He's in the back with him?
Might be.
Madam Prosecutor.
And I was gonna discuss. Because there are. I'm going to run to the restroom before we do that. And also I think Delane Phillips might also be a plea.
Okay.
Last time I talked to Mr. Harris, he was going upstairs.
Okay. whatever you decide. Yeah, when you get back, I'll be ready for Collins, Burgess, and then Phillips.
Judge, I don't want everybody to wait around for me. Perhaps we should just adjourn it. I've got a slow computer and we could adjourn 2 weeks. I think mom is gonna wanna be heard.
Okay, so
I won't be here in 2 weeks. Can we put it over to August 16th?
August 16th is fine.
That's fine. Thank you, Judge.
Thank you.
All right. So you have your date?
Yes, ma'am.
Okay, perfect. I'll see you in a little bit.
Thank you, Judge.
Bye. Thank you.
Thank you. Have a good weekend.
All right, so I have Russell. But no Russell. Mr. Roberts, you can come to the table.
Oh, thank you, Judge.
Mr. Barnes, huh?
Mr. Holmes?
Mr. Barnes for post eviction.
No, I never. The timing's pretty good. It's 12:05.
Oh, here, we didn't call.
He's
Russell.
here?
No, we have, I
Oh.
just have the file.
Oh,
So what do you want to do?
well,
They both left.
can we just put this on Monday? Because I was gonna
Yeah.
ask for a KPS, and so I want to give him a chance and give the defense attorney a chance to weigh in on it.
Monday. Put it over to Monday.
Okay, thank you.
All right, Collins.
Sorry, I was over here yip yapping.
No. Ready.
I'll take some.
Calling case 24001363-01-FH. People of the state of Michigan versus Hassan Collins. This case before the court today for review date. Appears for the record, please.
Elizabeth Kellogg on behalf of the people, P84687.
And good afternoon to your honor, Madam Clerk, Jonathan Roberts, P86428, on behalf of Mr. Collins, who stands to my left. Mr. Collins, could you please state your name for the court?
Hassan Collins.
Okay, all right, so we have a trial date on Monday, but it appears that the parties have reached resolution.
Yes, Your Honor.
Madam Prosecutor, for the record.
Yes, Your Honor, it will be a plea to the sole count one. There is a sentence agreement of 2 years probation. The people do consent to sentencing under HIDA, as Mr. Collins was 22 years old at the time of the offense. There are some special conditions on the term of probation. They are substance use screening, testing, and treatment as directed, mental health evaluation, follow-up treatment as directed, cognitive behavioral therapy and/or anger management classes as directed, and all other terms and conditions, fines, costs, and fees as set by the court.
And that is defense's understanding of the agreement which has been executed.
Okay, sir, is this what you would like to do?
Yes.
Okay, state your name, and this time I want you to spell it.
Hassan Collins.
Relax, relax. Okay,
Hasan Collins, Collins.
how old are you, sir?
23.
Okay, how far have you gone to school?
College.
Some college?
Yes, some college.
Okay, all right. I'm going to ask you a series of questions, okay?
Yes, ma'am.
At some point you don't hear me, you don't understand what I say, I want you to tell me, I don't understand. Can you repeat that? I can't hear you, okay?
Okay.
All right. Having said that, if I ask you a question and you give me an answer, I'm going to assume that you understood my question and that the answer you gave is the answer that you intended to give. Do you understand?
Yes, ma'am.
For the charge of police officer assaulting, resisting, obstructing, how do you plead?
Guilty.
I'm holding a form that sets forth the plea and sentence agreement in this matter. I'm holding this form up. Have you seen this form before?
Yes, ma'am.
Louder. Have him come right here.
Yes, ma'am.
Okay. So
Yes,
again, okay, perfect. So you've seen this form before?
Yes, ma'am.
Okay, I'm gonna ask you a question again. For the charge of police officer assaulting, resisting, obstructing, how do you plead?
Guilty.
Okay, all right. You said you've seen this form before. Is this your signature on this form?
Yes, ma'am.
Okay, all right. And did you sign this form after you had an opportunity to go over everything fully and completely with your attorney?
Yes, ma'am.
Do you have any questions at all regarding the plea and sentence agreement?
No, ma'am.
Do you understand that by pleading guilty to count one, police officer assaulting, resisting, obstructing, you are conditionally convicted of that 2-year felony and are agreeing to 2 years probation, which means that this conviction will not go on your record so long as you successfully complete all the terms and condition of the probation. Do you understand that?
Yes, ma'am.
Okay, and those terms are including but not limited to substance abuse screening, testing, and treatment as directed, mental health evaluation, followed by any treatment as directed, cognitive behavioral therapy, and or anger management as directed, as well as any other terms and conditions set by the court. Do you understand that?
Yes, ma'am.
Do you have any questions about anything I just said?
No, ma'am.
Do you still wish to proceed?
Yes, ma'am.
Okay, by electing to plead guilty today, you're waiving your right to a number of important rights that you would have if you were to go to trial. Those rights are listed on the form that you signed, but I still go over everything with you on the record to make sure that you understand. Do you understand that you have the right to be tried by jury?
Yes, ma'am.
To be presumed innocent until proven guilty?
Yes, ma'am.
To have the prosecution prove beyond a reasonable doubt that you are guilty?
Yes, ma'am.
Okay, do you understand that you have the right to have witnesses against you appear at trial?
Yes,
Do you
ma'am.
understand that you have the right to question or cross-examine those witnesses through your attorney?
Yes, ma'am.
Do you also understand that you have the right to have the court order any witnesses you would have for the defense to appear at trial?
Yes, ma'am.
Do you understand that you have the right to remain silent during trial? Do you understand that that right cannot be used against you? So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they cannot use your silence against you in reaching a verdict. Do you understand that?
Yes, ma'am.
Okay, and do you also understand that on the flip side, that you also have the right to testify if you chose to do so, to tell your version of facts?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up all the rights we just reviewed?
Yes, ma'am.
Okay, other than the plea and sentence agreement placed on the record here in court today, has anyone promised you anything else to get you to plead guilty? Anyone threaten you or any way force you to plead guilty today?
No, ma'am.
Do you understand that if I accept your plea, you will be giving up any claim that your plea was a result of a threat or promise unless you tell me about it right now?
Yes, ma'am.
Okay, I ask you again. Do you understand that if I accept your plea, you'll be giving up, hold on, you'll be giving up any claim that your plea was a result of a threat or promise unless you tell me about it right now?
Yes, ma'am.
Okay, are you currently on probation or parole?
No.
Okay, where's he on probation?
Oh, just for this.
So he's on bond.
Yes, it's just the bond.
Okay, so he's not on probation. Have any
No,
project?
Judge.
Okay, all right. Do you understand that by pleading guilty that you're giving up the right to appeal your guilty plea as a right? And even though the Court of Appeals may grant you leave to appeal, it is not obligated to do so?
Yes, ma'am.
Do you understand that if your plea is accepted, that you may be giving up the right to appeal issues that otherwise would be appealable to you if you were convicted at trial?
Yes, ma'am.
Sir, please tell us what you did on or about February 20th, 2024 at or near Grand River Avenue and West Grand Boulevard in the city of Detroit, county of Wayne, that makes you think you committed this crime. What happened?
I seen police officer. I knew the police officer, knew a police officer, and I still ran.
Okay.
People are satisfied, Your Honor.
Defense is satisfied, Judge.
The court finds that the plea is understanding, voluntary, and accurate and will accept the guilty plea. Mr. Collins will be referred to the probation department for pre-sentence investigation report. We will set sentencing for, let's see. And I will now, since the court has accepted the plea, I will take Monday's trial off the calendar. And Corporal Beatty is, for the record, is giving you a map. Sir, you'll go over, your attorney is telling you now, you'll go over to the probation department and you'll help them out with this to schedule.
Thank
this
you, Judge.
pre-sentence
Yes.
Investigation interview.
And
At this point, it's gonna have to be after our move. I think sentencing, it's tighter, so I don't think that that's an issue. That's not an issue from the people's perspective, is it?
No, Your Honor. Thank you.
September 11th?
that works for defense, Judge.
Okay, sentencing is on September 11th.
And if we could address bond, I know we've had very extensive conversations about Mr. Collins' situation with the tether. And I, again, want to thank this court and staff for coordinating his release. I think since we've accepted the plea and the sentencing date is so far out, I just don't want him to continue incurring the cost of maintaining the tether. I will be fully accountable to make sure that he is here on the 11th. If he's not here on the 11th, I fully understand what Your Honor would be inclined to do to ensure that, you know, I mean, if the hide even's still on the table at that point, but I would just ask that the tether be removed leading up to sentencing.
So you can't assure he's gonna be here. You haven't been able to ensure he's going to be here. So as an offset, and this is not really like a negotiation,
No.
but I hear what you're saying. He's gonna keep it on. I think that's for to keep everybody comfortable and starting with the court. However, I would entertain adjusting some of those court costs.
Thank you, Judge.
result on the back. That's it. All right. Okay. We'll see you then. Thank you. Off the record. All right. Okay, we have Mr.
Burgess for Benson.
Yes.
Yes.
And then we still have Mr. Harris back.
Did he go upstairs, you said?
Yes, yes, he did.
You could tell him I'll be ready for about 10 minutes. Where's the evidentiary? No.
I could put it where it says motion is timely field. I could take that out and put evidentiary hearing.
Yeah, do that. That's yeah. Okay, really? That's the same way I felt when I read this report. You know, he's shaking his head like he can't believe it.
It's just situation he's in.
Yeah, yeah. Like I said, that's the same way I felt when I read his report.
Yeah.
I literally shook my head. I'll talk more about that at the end. All right.
Calling case 24002689-01-FH. People of the state of Michigan versus Aaron James Benson. This case is before the court today for sentencing. Appearances for the record, please.
Elizabeth Kellogg on behalf of the people, P84687.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Aaron Benson, P58557.
Okay, state your name, sir.
Aaron Benson.
Okay, today is a date time set for sentencing. Madam Prosecutor, have you gone over this report?
I have, Your Honor. I have no additions, deletions, or corrections. I believe guidelines are scored correctly at 14 to 29.
Okay. Mr. Burgess, have you gone over this report?
Yes, Your Honor, I've reviewed it. No additions, corrections, deletions. The guidelines do appear to be scored correctly at 14 to 29. Obviously, the court's aware there was a sentence agreement in this case, asking the court to follow.
Okay, sir, I just need to hear from you directly. Have you gone over this report with your attorney?
Yes.
Any changes, deletions, corrections to this report?
No.
Okay. Anything from the people before sentence?
No, Judge. Thank you.
Nothing further.
I just asked the court follow the sentence agreement, Judge.
Sir, do you have anything you would like to say before sentence is imposed? Okay, there was a sentence agreement in this case for the charge of operating while intoxicated. Third, you are sentenced to a minimum of 2, maximum 5 years in the Michigan Department of Corrections. The sentence will run concurrent to the sentence imposed in case 23139701FH. Jail credit is 21 days. The following fees are assessed: crime victims assessment $130, court cost $1,300. There's a fine imposed of $500. State cost $68. Pursuant to the terms of the plea agreement, counts 2, 3, 4, and 5 are withdrawn. The habitual 4 is withdrawn. Oh, let me back up quickly. This report, I think this is an error on this report, within this report. Page 9 of this report, where it has its history. Go to that for a minute. Where it says 12 of 13. Do you see where I'm at?
Sorry.
Judge, you said, page,
It says page 9 on the bottom,
okay,
but for his, it's where it has all of his history.
yes.
So it's number 12 of 13 that I'm looking.
All right, I see that right here.
Okay, so for the narrative, a violation of probation on 5/14/2024, defendant's probation was revoked and he was sentenced to 29 months to 5 years. He wasn't on, hold on, no, I got it. That wasn't what happened.
Correct.
Yeah, he was out awaiting sentencing. He failed to appear for sentencing,
Right.
at which time he picked up this case, and at which time Judge Hathaway did not honor the agreement, and then he imposed that sentence of
Right.
29 months.
I didn't catch that, I'm sorry.
Yeah, no, that's okay. So then the narrative is just wrong, so I'm going to have to. So I think what this needs to say is defendant failed to appear for sentencing and picked while in absconding status, picked up the case, this current case.
Well, I don't think he was in absconding. I think he picked it up while he was on bond, Judge. I don't think they had issued a KPS while he picked up the new case, so.
You know what, you're right, he picked up, right. Judge Hathaway signed the failure to appear for sentencing, and this was
After the offense.
Okay,
The offense,
all right.
Yeah, I just didn't want it absconding.
Okay, so. Okay, so it's gonna say defendant picked up the current case while out on bond on this case, which is the 12 of 13.
Okay.
For the narrative, I'm changing that narrative to say that. Okay, picked up while he was on bond, and then he was sentenced to, he was not on probation, that was just completely, it's just wrong, okay. But it does get confusing if you don't know it, so. Then- Okay, I'll send this back for correction.
Judge, there was one other issue I just wanted to mention that I didn't catch. I'm sorry.
Okay.
I'm not sure if it's a correction or not, Judge, but they have him, they gave him 21 days jail credit, but they have him in custody in the Wayne County Jail, excuse me, from 4/24 to 7/19/24. I understand they're saying he's not eligible because he's serving a prison sentence, but this case was pending and he's already in custody on this case while sitting at the Wayne County Jail. I think he should get credit for I think it's 86 days, Your Honor, 4/24 to 7/19/24. He wasn't on parole. He wasn't on parole already. They were kind of cases that pended at the same time while he sat in the Wayne County Jail the whole time.
I think he might get there. What's the people's position?
Your Honor, I wasn't exactly sure, and I
That's
just
a
told
different
defense
issue,
counsel that maybe a minute or two ago, but as I'm thinking about it more and listening to Mr. Burgess's argument, I do think he is eligible. This wasn't a situation where Mr. Benson committed, misconduct after being, arraigned on this, and his bond was revoked as a result, where and the statute would say you're not eligible if there's been some misconduct with relation to this case. So I think he's eligible, and also that would be in the spirit with the people's sentence agreement, that this sentence be concurrent with his other sentence.
Okay, so I'm gonna change the jail credit to how many days?
I got 86 unless you want to do that.
Your Honor, I could do the math really quickly.
Give me the days again so I can change the dates.
April 24th through July 19th.
Okay. Oh, they just did that.
I got here the 27th that night.
Okay.
Myself in the West.
Let me see. Yeah, he did walk into Westland on the 22nd, Judge. They have it the 24th, but that's, I mean, I'm not sure how the court wants. He was in custody, even though maybe not at Wayne County, but he was in custody in
I came here
Westland.
that night.
Right,
That night they got me on the bus.
right. They would have recorded it the next day.
Judge, counting today, it's 87 days. So plus the 1 day from the initial arrest, that would be 88 days.
We have no objection to that, Judge. Ms. Keller's probably better at math than I am, so.
Yeah.
No, you did.
Okay. Yeah.
I did it in my head. I was like 6 to 31.
I think I've gotten through all the fees. Fine, $500. I know I said that. State cost $68. Appellate rights. It is my duty to advise you that you have the right to request leave to appeal from the Court of Appeals. If you are unable to afford an attorney to prepare post-conviction motions or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare post-conviction motions or perfect an appeal. You are further advised if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. You've just received a form advising you of these rights, and I request that you sign receipt of that form with the clerk within 42 days of today's date if you intend to appeal and need to have counsel appointed for you. So I really shook my head at this. You know, his guidelines were higher. I would not have accepted, you know, anything less, but his guidelines are what the guidelines are. I mean, this record is terrible, and this really does need to stop before you kill.
Got the 2 right away. I fell for it.
Yeah, but before you kill yourself
I tried
or someone
to, but the
else.
problem was-
Okay, well, this has got to stop, or you're gonna be in front of a
Yes,
court on completely
it's
different
stopped.
charges. Okay, I hope so. He's all set, baby.
No, man. Thank you. Thank you.
Okay, Sarah just typed.
Is this credit?
Eighty.
So
I just emailed it to the clerk. Hey, I have a
Mr.
question.
Harris,
Just,
are you ready?
not quite.
Okay. You need to talk to me or you talk to your client or?
Right.
Okay. have the file already. Is that plea form signed or not yet?
Not yet.
Okay.
Did I print that plea and give it to you already?
Yes, thank you.
$719.
Calling case 24-002274-01-FH. People of the state of Michigan versus Delane Phillips. This case before the court today for pretrial. Here's for the record, please.
Elizabeth Kellogg on behalf of the people, P84687.
Good afternoon, Your Honor. Wyatt Harris, P54891 on behalf of Delane Phillips, who sits to my left. Mr. Phillips, would you rise and give your name for the record?
Delane Phillips.
Okay, thank you. Okay, so we have a trial date, still some time out. We're here for pre-trial, but it appears that the parties have reached resolution. Ms. Kellogg, please place the terms of the plea and sentence agreement on the record.
Yes, Your Honor, it's going to be a plea to count 1, operating while intoxicated with a high BAC, third offense notice. The people agree to dismiss counts 2 and 3 and withdraw the habitual offender fourth offense notice. There's a sentence agreement of 2 years probation, first year Wayne County Jail, substance abuse evaluation and treatment as recommended, 100 hours of community service, and any other terms, conditions, costs, fines, and fees the court may set.
I've discussed this with Mr. Phillips, Your Honor, and he wishes to avail himself of the offer.
And it's my understanding this is a true third, correct?
Yes.
Yes.
Okay. Sir, is this what you would like to do?
Yes, ma'am.
Okay. I need you to state your name again and spell it this time.
Delane Phillips, DELANE PHILLIPS.
Okay, to the extent that you can, raise your hand. Do you swear, you're fine. Do you swear affirm the testimony you're going to give the court will be the truth?
Yes, ma'am.
Okay, how old are you, sir?
60,
How far have you gone in school?
like the 10th grade,
Okay, do you read, write, and understand the English language?
a little bit.
You said a little bit?
Yes, ma'am.
Okay, so Mr. Harris would have showed you a form. Well, I'll ask you, have you seen this form before?
Just now.
Just now, right. Okay, is this your signature on this form?
Yes, ma'am.
Okay, did Mr. Harris go over this form with you?
Yes, ma'am.
Did you sign this form after you had an opportunity to go over everything fully and completely with him?
I just signed.
That wasn't my question. My question is, did you sign it after he went over everything fully and completely with you? What's on this document?
Yes, ma'am.
Okay, all right. So I'm going to ask you a series of questions. And at some point, if you don't hear me, if you don't understand me, if you don't understand what I'm saying, I want you to stop me and interrupt me so that I can repeat the question or explain, okay?
Yes, ma'am.
Having said that, if I ask you a question and you give me an answer, I'm going to assume that you understood my question and that the answer you gave is the answer that you intended to give. Do you understand?
Yes, ma'am.
For the charge of operating while intoxicated with a high blood alcohol content, third offense notice, how do you plead?
Guilty.
Okay, so again, I'm holding a form that says for the plea and sentence agreement. You indicated that you signed it. You indicated that your attorney went over the document with you, correct?
Yes, ma'am.
Do you understand that by pleading guilty to count 1, operating while intoxicated with a high blood alcohol content, third offense notice, so that takes it from a 93-day misdemeanor to a 5-year felony, you are automatically convicted of that charge. Do you understand that?
No, ma'am.
Okay, but so your options are you plead guilty or you go to trial, right? You understand that?
Yes, ma'am.
Okay, so you're automatically convicted. It has a statutory maximum of 5 years. Do you understand that so far?
Yes, ma'am.
Okay, and that, do you understand that you're agreeing to 2 years probation with the first year in the Wayne County Jail?
Yes, ma'am.
Okay, substance abuse evaluation and treatment is recommended.
Yes, ma'am.
100 hours of community service as well as any terms, conditions set by the court. You understand that?
Yes, ma'am.
Any questions about anything I just said?
Right.
Louder?
No, ma'am.
Do you still wish to move forward with this plea?
Yes, ma'am.
Okay. By electing to plead guilty today, you're waiving a number of important rights that you would have if you were to proceed to trial. Those rights are listed on the form that you signed that Mr. Harris went over with you, but I'm still going to go over everything on the record to make sure that you understand. Do you understand that you have the right to be tried by jury?
Yes, ma'am.
To be presumed innocent until proven guilty?
Yes, ma'am.
To have the prosecutor prove beyond a reasonable doubt that you are guilty?
Yes,
Do
ma'am.
you understand that you have the right to have witnesses against you appear at trial?
Yes,
Do
ma'am.
you understand that you have the right to question or cross-examine those witnesses through your attorney? Do you understand that you have the right to have the court order witnesses on your behalf to appear at trial?
Yes, ma'am.
Do you understand that you have the right to remain silent during your trial?
Yes, ma'am.
Do you understand that you have the right to not have that silence used against you? So in other words, if you decided to proceed to trial and not testify, I would instruct the jury that they cannot use your silence against you in reaching a verdict. Do you understand that? On the flip side, do you also understand that you have the right to testify on your own behalf if you so chose to do so?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up all the rights we just reviewed?
Yes, ma'am.
Other than the plea and sentence agreement placed on the record here in court today, has anyone promised you anything else to get you to plead guilty? Did anyone threaten you or any way force you to plead guilty today?
No.
Do you understand that if I accept your plea, you will be giving up any claim that your plea was a result of a threat or promise unless you tell me about it right now? Are you pleading guilty voluntarily and of your own free will?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that by pleading guilty that you are giving up the right to appeal your guilty plea as a right? And even though the Court of Appeals may grant you leave to appeal, it is not obligated to do so?
Yes, ma'am.
Do you understand that if your plea is accepted, that you may be giving up the right to appeal issues that otherwise would be appealable to you if you were convicted at trial?
Yes, ma'am.
Sir, please tell us what you did on or about April 10th, 2024, at or near Jefferson and Catview in the city of Grosse Pointe, County of Wayne, that makes you think you committed this crime.
I was driving under the influence.
Okay, when you say you were driving under the influence, what do you mean by that?
I was drinking.
You were drinking?
Just driving under the influence. I was drinking. I mean, how?
Mr. Phillips, had you been drinking alcohol that day?
Yes.
And while you were drinking the alcohol, had you been driving?
Oh, I wasn't driving when I was driving, but I
Okay,
was drinking.
but you did get in the car and drive after having drunk.
Your Honor, if I may. Mr. Harris, will you stipulate that Mr. Phillips has 2 prior OWI convictions?
Yes,
Will you also stipulate that when his blood was drawn during this investigation and sent to Michigan State Police to be tested, it returned a result of 0.235 grams of alcohol per 100 milliliters of blood?
we so stipulate, Your Honor.
Your Honor, the people are satisfied.
Are you satisfied?
Yes, I'm satisfied, Your Honor.
I mean, why was there a question? Were you driving a car, sir?
Yes, ma'am.
Okay. Were you under the influence when you were driving a car?
Yes, ma'am.
Okay. The court finds that the plea is understanding, voluntary, and accurate, and will accept the guilty plea. Mr. Phillips will be referred to the probation department for pre-sentence investigation report, and the court, having accepted the plea, will take the November 4th trial date off the docket. All right, sentencing will be in custody, so I can put this in for. Madam Clerk, how many are on this night right now?
That 9 criminal and 14 evidence.
Oh, no, that's fine. August 9th, are you available?
August 9th's gonna be a little tight, Your Honor. The following week, I'm on vacation. Can we do it either the 8th or the 7th?
I'll squeeze it in. That's fine. Let's see. Let's do the 8th.
Okay, thank you.
Okay, sentencing is on August 8th, and again, he is referred for a re-sentence.
Come on back, Mr.
Okay, off the record on Phillips.
You haven't been sentenced yet, Mr. Phillips. I'm gonna come visit you before you, Phillips.